The law then allows Citrus County to impose that fine as a lien on all of your real or personal property, and the county may foreclose on such lien or seek money judgment against you after the lien has been recorded for 3 months. I'm telling you this because I may not give you another date to appear before me, and therefore you likely will not have another opportunity to plead your case or to explain why you didn't comply with the county code. The county will continue with its liens against your property until you notify the county of your compliance. In all cases in which I find someone guilty of a violation, I will impose all costs required by county ordinance or regulation. If you fix the violation in the time allowed, that cost will remain minimal. If you do not timely fix the violation, you'll be responsible for additional costs as well as the cost of the lien imposed. If I find you guilty of a violation and allow for a continuance of your case, you will be required to return on a certain date. In the time between hearings, I'll require that you comply with the county and its codes in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each of the days of violation from today's date forward. Your failure to return on the next date may be deemed evidence of your failure to cooperate with the county. Are there any appeals of orders to demolish today? Okay. Ladies and gentlemen, you do have the right to appeal any order that I make today as provided by law. Thank you.
First case on today's agenda, Philip Baumhoff Jr., case number 216-2817, Officer Jillian Nocella, assigned to the case, page 8 of your agenda. Carl Jones, Building Director's expert on the case.
Sir, I make you stand up. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
You don't need to be sworn. You're an attorney.
Thank you.
All right, thank you.
Jillian?
Actually, I'm sorry. Sir, can you state your name for the record?
Sure. Craig Taraski.
Thank you, sir.
I'm sorry.
Jillian Nocella, Citrus County Code Compliance Officer. This is case number 216-2817, Chapter 18, Article 1, Section 18-8A, obtaining after-the-fact permits for all construction or modifications of the Citrus County Code of Ordinances. The address is 8123 South Locanto Highway, Locanto, Florida. Property owner is Philip Baumhoff Jr. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 20th, 2022. Photos taken at my last inspection, July 19th, 2022. And the property summary page printed from the property appraiser's website. And Exhibit B, a copy of the notice of violation, copy of the notice of hearing, and a copy of the certified mail return receipt indicating good service.
So, sir, what I normally do at these hearings is I ask you to take a look at what's been proposed as the exhibits and to let me know if you have any objection to them being evidence in this hearing. Have you seen them yet, or?
No objection.
Thank you, sir.
And we do have some other exhibits we might be submitting to testimony of other witnesses.
In other words, the county has its own evidence and witnesses. Okay.
We might have some additional witnesses.
Oh, who are not present?
Oh, they're present.
Oh, okay. Okay.
Yes, they're present. There you go.
All right. Then, without objection, what's been proposed as exhibits A and B will be evidence.
On April 19th, 2022, information was received from the building department and a case was opened in regard to the construction of a farmer's market / gift shop at 8123 South Locanto Highway in Locanto. Research was conducted in Hanson and permit number 2022-04419 had been applied for after-the-fact construction, however never issued. On April 20th, 2022, an inspection was conducted at the property. During that inspection, it was observed that the building on the property being used as the farmer's market had indeed been constructed and done so without the permits. On July 19th, 2022, the building still remains, and as of today, no permits have been issued for the work done after the fact.
Have you had conversations with the property owner or legal counsel about this?
I have not, no.
Okay. Does the county have any other witnesses who wish to testify on this?
We have Joanna Coutu and Mr. Carl Jones.
Well, do you want to present the testimony now or not? It's up to the county.
Are we,
I don't-
have the documents been admitted into?
Yeah, they were admitted.
Okay. Yes, we'll have Mr. Carl Jones testify.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Good morning, Mr. Jones.
Good morning. Am I correct that the building in question here is mostly the farmer's market? Is that
Yes.
what we're addressing?
And were there, can I ask a few questions?
Yeah.
Mr. Jones. Mr. Jones, did your department issue notices of noncompliance for failure to pull building permits?
Yes.
For buildings on the property, on Mr. Bonhoff's property? And what buildings?
There are 3 buildings of concern. One was a very large restaurant building. The second building was what we call a wedding venue. It's an assembly type building where weddings might take place or special events. And then the third building is a smaller building to the north side of the property that is kind of a gift shop retail store that has a restaurant component in it where people could go and buy lunch. And
After the notices were issued, did the owner apply for building permits?
yes, all 3 buildings permits have been applied for. Permits have been issued for the wedding venue and the large restaurant. And those 2 buildings are currently working towards getting a CO. I think the only thing still outstanding from those buildings is final inspections and final approval of the various systems.
With regard to the market, was the permit ever issued?
The permit has not been issued. Their application, let me see here. I won't be able to give you an exact application date, but it was approximately February of 2022 when they applied for the market building. Reviews were done by various agencies within the county, and most of the comments, denial comments, went out on March 23rd.
Are you reviewing documents that are helping refresh your recollection on this?
I am.
In other words,
I
are you
am.
testifying from memory when you testify right now?
I'm reading my official
Okay.
records that are in the county
Okay.
permitting system.
What records are you looking at right now?
This is the permit history.
Okay.
We use a permitting software called Hanson that maintains records on all of our activities associated with permit applications and inspections and so on. And
So I need to understand that when you testify so that I know where you're getting this information.
yeah, this is coming from our official records, and it's all public record.
Right.
So anyway, the plans and specifications were reviewed on or about March 23rd.
Why hasn't the permit been issued?
There were lots of discrepancies and deficiencies in the permit application package.
And there weren't similar deficiencies for the other structures?
Oh, there were in the beginning, but the applicant, through the process of review and resubmittal and re-review and resubmittal, those permits ultimately did get issued.
Are you aware, before, I certainly want to hear from the other side, but I mean, are you aware of any of the reason why they were all rectified for 2 out of the 3 structures, but you still don't have them rectified on the last one?
Well, rectifying a discrepancy is 100% on the
I
applicants.
Agree. I agree. I just didn't know if you knew the reason.
I don't know why they would not have been rectified.
Okay.
I mean,
okay. All right.
but for whatever reason, we have not gotten resubmittals that satisfy the discrepancies, and the permits have not been issued.
Is the county claiming for the purposes of this code violation that there were 3 separate violations, or just 1 violation for the structure for which a permit hasn't been issued yet?
Originally, there were 3 violations because the permits had not been issued.
Right.
And technically, I suppose the 3 violations are still there because no COs have been issued for the other 2 buildings. To come into complete compliance, we would expect a certificate of occupancy to be issued for all 3 buildings. But
Well,
right now, I think our focus is the market building.
I was going to ask you, was the matter regarding the marketplace turned over to code compliance for them to proceed?
Yes.
Okay, and so it wasn't turned over to code compliance for the 2 structures that already have permit. All right,
Correct.
so the reason why I'm asking is because I'm looking at the code section, section 18-8, subsection A, and it says that any person commencing construction for which a permit is required without having first obtained such permit in addition to the penalties described in this chapter, shall also be subject to a penalty equal to double the permit fee. So the county's not going to seek a penalty equal to double the permit fee for the 2 structures for which a permit has already been issued.
No.
That issue of assessing fees is all resolved.
Okay.
And we're beyond that for those 2
That's for
buildings.
the other 2, because they got the after-the-fact permits?
Yes.
And do they pay twice the amount of the fee for that?
I didn't come prepared to answer that. I don't
Okay.
know.
Have you been to the market?
I have.
In the market when you apply. What's,
You can proceed.
All right.
I'm not waiting. Yeah. Yeah, please. Yeah.
Take the roundabout way. Mr. Jones, could you take a look at that? Have you seen those photographs?
Yes, I have.
When have you seen those photographs?
I can't give the exact date, but I did participate in a meeting at the marketplace that took place between the county, the owners and managers of the market, and Department of Business and Professional Regulations. We all met on site inside the market, and we had a meeting there, and it was in regard to issuance of liquor licenses.
Do the photographs accurately depict the property?
Yes. Yeah. This is what I saw when I was there.
And with regard to, this has been marked as Plaintiff's Exhibit D.
Is there any objection to what's been proposed as this?
The reason I was saying that was because I was going to refer to certain pages of it so that you can.
Well, I know, that's why
All
I'm
right.
going to ask if opposing counsel has any objection to it being evidence.
the photographs?
Yes.
No
All right.
objection.
Then it's going to be admitted as C, okay?
Yes,
Exhibit C.
it's just been marked as D, sorry about that. Could you take a look at the page that's marked D4?
Yes.
Does that accurately depict the interior of the market?
Yes.
The same question for pages D5 and D6 and D7.
Yes.
And that accurately depicts what you viewed
Yes.
when you were there. And are these photographs part of the building department's file?
I believe they are. I want to say they were taken by Janine Newman, which is one of my employees.
What was the date they were taken?
According to the date stamp on the photos, it was April 6th, 2022.
Thank you. So these photos were taken before code compliance received a complaint about it?
I don't know the exact date that code.
I thought
Received
there was
the complaint.
testimony that the first complaint was on April 19th.
As Mr. Jones testified, the matter was turned over to code compliance by the building department
Okay.
when there
Okay.
was not a permit.
All right.
And could you take a look at what's marked as page D12 and D13? Is that the exterior of the market?
Yes, it is.
And those photographs have a different date than what you stated as to the other photographs. What's the
Yeah,
date?
they're earlier. These two photographs are earlier, March 29th.
Based on what you saw and when you were at the property and based on your knowledge of the building code, do these constitute farm building? Does this building constitute a farm building?
If you take a look at Exhibit D12 and D13, you'll actually notice that there's what appears to be two separate structures with some kind of a connecting breezeway. The structure on the right, which would be the east, could be considered a farm building. The structure to the left clearly is not. And that's the structure to the left is what we're calling the market building.
And from what you observed the day you were there, did you determine whether or not it was used primarily for farm purposes?
I did make that determination, and it was to the negative.
And in other words, you determined it was not being used as a farm building?
And that is a mercantile building. It is a gift shop restaurant type structure.
As a gift shop restaurant type structure, is it subject to the building code?
Yes, it is.
Thank you. I have no further questions for Mr. Jones.
I think I understand what the county is presenting, so I'd certainly like to hear from Mr. Juraski and what's
Sure.
going on here. Thank you for
Sure.
your patience.
I think a little bit more context
Yeah.
would be helpful.
I did have
So the
Joanne.
property was originally developed as an active farm. So there's they actually cultivate and harvest blueberries on site and produce blueberry wine. So the original operation was contemplated to be allowable under the Right to Farm Act as agritourism. There was some dispute on whether those were farm buildings, and the owner agreed to proceed to obtain a PUD approval for the operation for the other two buildings aside from the market originally. That was the PUD, and then more recently, as of I think last summer, maybe in August, added the market into the PUD.
Really? So the PUD didn't include all of it at first?
At first it did not.
Really? Okay.
So the market was added last August to the PUD. So you can see the substantial steps have been taken to clean up the entitlement piece of it. And also you've already heard testimony that building permits have been applied for, and the applicant and their contractors have been diligently working through the various review comments to clean those up and get those issued. Sounds like there still may be a gap in the permitting for the market, but just as they have for all the other buildings, they're committed to getting those permits in place and getting the CO. I think the complaint in the photos you see in Exhibit D show an active operation. That business is no longer open, so I think that should calm some of the concerns by the county that there would be an operating enterprise without COs.
Have you been in touch at all with the county to let them know that?
I think
Until today?
I think they're aware.
Okay.
Yes.
Well, I guess my question was just if you guys had communicated that to them.
Uh,
They may be aware, I just didn't know if you've communicated it.
I believe they're.
I can't accept your
I-
testimony,
yeah.
yeah, unless
He's gotta
you're
come-
sworn in.
I can't testify to
Okay,
that, so.
all right. If you don't mind, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did. My name is Phil Baumhoff Jr. I'm the owner of the property. We received the original code compliance complaint, I believe, back in May. I did a response by certified mail. Never got any response back from the county. And I explained to them that we weren't permitting. They can check the Carl Jones and all that. Never even received a response, written or anything from them. They just immediately set it for this hearing today. We took the steps that we just shut it down July 1st because we just felt it was best at this time. But also just to recap a little bit what he said, because obviously I've been involved with this day to day, so understand it a little bit better. Yeah, the market was never initially anticipated to be what it was. It was truly for our U-Pick operation in the fall farm festival, pumpkins and stuff like that. It grew a little bit bigger. When the county came to us, they asked us, they thought it was outside of the ag or the ag tourism. I said, okay, so I agreed. So we went ahead and modified the PUD, which was approved through the building department and then through the county commissioners. That was in April, the approval came through. Once the approval came through, it takes time. You had to have it resurveyed to add that into there and then do all your engineering. Dr. Michael Wilburn is the one working on that. Then you get all that together, submit it, then you have your process.
Yeah, it's
where it
not a
goes back and
painless
forth.
process. I'm
No,
aware, and that's why I was surprised that it wasn't all as part of the PUD in the beginning,
Well,
just because.
Yeah, because the building was we never thought it would grow to what it did into that market. And I said, we kind of agreed with them that it probably was outside of agritourism or the ag statute. I mean, we could have argued either way, but I was trying to disagree with them and just include it. I was also the first impression was that if we went over a certain acreage with our PUD, it would change the PUD, and they said, we found out no, by adding that additional 2 acres, it should not change anything. But like we said, going back and forth over a lot of issues, adding that extra 2 acres, it brought up a lot of things from extra retention areas and things that are just not cost effective for what that place generates, to be honest with you. So we've been going back and forth. And even the other two buildings down below, they've taken some time, and financially it's been extreme hardship. And some of it my personal feelings, I blame on the county, and some of it I blame on COVID. Two whammies hit us. One is we were originally informed we didn't need sprinkler systems for the two buildings down there, fire suppression sprinkler systems. We have no water service out there, and so on. That's a very expensive, a very intensive opera. COVID hit. Those people that do that type of work, tanks and everything, became non-existent. So that really set us back. But we're very close to having those buildings
That
TCO.
explains some context on the permit issues.
Yeah.
But ultimately, this code section is pretty clear on how it applies. In other words, it sounds like some after-the-fact permits need to be acquired. So, I mean, the county's only proceeding on this one case. I think technically they could have proceeded on the others.
I believe we're waiting for them. That we resubmitted, because you go back and forth.
Well, it doesn't matter who's waiting for who. You can't do anything until you get the permit. So, I mean, that's the point of the code section.
Well, we're not doing anything.
Yeah.
You did. You constructed without a permit.
No, I did not. We were under agricultural land. We have a right to construct. The county knew about those
Oh,
buildings.
so your defense, you have a defense, and you're saying
Yes.
that your defense is that you didn't need a permit at the time.
Correct.
At the time.
I see.
At the time the structure was constructed.
Right.
And then
But
the business that evolved within that structure may have tipped the
I
scales
understand
the
what
other
you're saying.
direction.
Okay, so now I understand.
And the county was aware of that, because our septic, when you build under agricultural.
When was the county aware? When were they first aware of it?
They've always been aware, because they watch me like
Give
a
me a
hawk.
date.
But
If you
with
can't,
that
give me a
said,
date.
I would not know, but you can check our permitting for our septic, because
Okay.
when you build under ag, the one thing you do have to get permitted is your septic. And our septic was permitted for their under ag, so that's in the record, you'll see that. That was allowed. So they knew it was there through the septic permitting and everything, and it was rightfully built under ag.
If you don't mind, let me turn back to the county,
Yes.
and maybe we should go through the rest of your witnesses.
Yes, Joanna Coutu, I'd like to call her as a witness. Well, looks like Mr. Jones has something to say.
So I normally I only turn to the other side once I feel I've understood the case. I thought I fully understood the case. Now it appears that there are some serious issues, so I'd welcome further testimony from the county.
I'd like to clarify one comment. When applying for a septic system, that application is given to Environmental Health Services, which is a state of Florida agency, not a county agency.
Correct.
So we would not necessarily have received any information regarding septic.
But I don't know
approval.
if you did,
I don't know if we
can
did
you
either,
represent,
but
I'm sorry, Mr. Jones.
It
Can you
doesn't count.
Can you represent to me that the county did not receive any information about the septic at the time that it was applied or approved?
None that I'm aware of.
So,
That's my testimony.
yeah,
I'm not aware of any.
You don't know.
Right.
Okay. Who would know for the county? Okay. It may be relevant. I don't know.
Yeah.
So,
Another thing that I'd like to speak about is that there are certain agricultural buildings that can be built. The Florida statute specifically says non-residential agricultural buildings can be built without permits. They're exempt from Florida building code.
right.
However, there is a process by which one gets permission to do an ag building, and that is by submitting a request for an agricultural building. The applicant fills out the request. Our intentions are to build this building. They submit a site plan. We do the site plan review to make sure the building is located properly and that it does qualify for an agricultural exemption, and then the ag exemption is granted.
And are you saying that wasn't done here?
I have no recollection of it being done. We can find no record of it, and I
What-
don't believe it was.
What code section requires that
I
site
don't-
plan review?
I don't know that.
Okay.
I don't know that.
I'm sorry, I heard you and I wanted to jump up.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning. Joanna Coutu, Land Development Director.
Ms. Coutu, have you been involved with the PUD applications regarding the Bonhoff property?
Absolutely, both of them.
Okay, can you tell us when the first one?
The first one for the two buildings was approved in November 13th, 2018 by the Board of County Commissioners, and the Market Building was added on October 12th, 2021 by the Board of County Commissioners.
When the PUD application was filed that was approved in 2018, was that the barn event building?
The restaurant event barn area, yes.
What property did that cover? How many acres?
I'm sorry, I didn't bring that with me. I know in 2021 they did expand it.
How much of this property is classified as agricultural land, do you know?
I think it's about 25 acres. It's in the rear where their blueberry crop is.
And what kind of agricultural use did the property appraiser give it?
It's blueberry farm.
I've got 37.33 acres for the parcel in Exhibit A, page 6 that you gave me, so I don't know if that encompasses the whole thing or not.
I think that's the entire parcel.
Okay. It appears to have a homestead exemption.
Yes, there's a house there as well that's out. Both the blueberry farm and the house are off the PUD site area.
Okay.
Are you familiar with the property appraiser's records regarding this property?
Somewhat, yes. Don't have it memorized. That's why I'm not positive on that acreage.
Here, I'd like to show you what I have marked as Exhibit E.
Thank you, ma'am.
Are you familiar with that document?
Yes, this is a property appraiser's expansion when you click on it.
And it includes all of the different uses of the property, the entire parcel?
It appears to, yes.
Of the land that was classified as agricultural, was any of that agricultural classified acreage included in the boundaries of the PUD?
No, the PUD was not an ag PUD. It was a non-residential PUD.
And was any of the land classified as agricultural?
Not at that time, no.
In the
Has-
PUD.
In the PUD, right, the PUD area.
And has it been classified as agricultural since then?
No.
I'd like to show you what's been marked as, it's marked as C.
Well,
Exhibit
if you
C,
don't mind,
but
hold on. So let's see. Are you seeking to admit this document? That
I will be, yes.
Okay.
It's just the
I just want
appraiser's
to give
record.
opposing counsel a chance to review this and let me know if they have any objection to it.
Do you want me to give her my copy?
I think we
That's
have
not
one
what you were
copy.
cited for, so I'll
Oh, you
address
do?
that.
Okay.
Also, the whole
And here, I
property
have
is
another one if you want.
agriculturally exempt.
Read along.
Property
Yeah, that'd be
except for
great.
like
Or I can give you
20 for
mine.
homestead.
Once it's
So that's
admitted, I
fine.
can look at it.
Okay.
Mr. Drosky, can I ask you to take a look at the document that you were given that
Next
says
one.
Exhibit E and let me know if you have any objection to it being evidence?
Unfortunately, I will object to it being introduced as evidence
Okay.
to the extent that, this is essentially a tax record, and the appraiser's staff are not available to cross-examine, so.
Do you have any concerns about the authenticity of what it is?
No questions about the
Okay, then what I'm going to
authenticity.
do is I'll admit it, and of course you'll be able to comment on it to the extent you don't think any of it's accurate. It'll be admitted as Exhibit D, and I believe you have another document, Ms. Antrim? that-
Yes, I do. It's been marked as plaintiff's Exhibit C. Could you tell us what this is?
Yeah, the first item, the aerial, is the PUD, PUD area, the Planned Unit Development Master Plan area. And the second document is a locator map from something. I'm sorry, I don't know where that reference is from, but looks like Google Maps, something like that. The first item outlined in yellow is something we used in our presentations to demonstrate the PUD area for the county commissioners.
Was this the original PUD area?
This is a second PUD.
This is the second PUD,
Right.
meaning this is the PUD that incorporates the building that we're here
Correct,
talking about.
correct.
Okay.
Is any of the property that's located within the yellow lines on Exhibit C1, what's been marked as C1, agricultural classified land?
No, it was not limited, it was not told that in the PUD, it was not represented that way, so although I'm not with the property appraiser, I will say no.
And is the market building depicted on C1?
You can see a blue, it's expanded quite a bit, it doesn't quite look like that anymore, but yes.
Get the old tax record.
And how much has it been expanded, do you know, since this PUD was approved?
The most recent permit had a couple thousand more square feet, so I don't know the total square footage. It's expanded since then.
I would request that what's been marked as Exhibit C be put into evidence, or accepted into
That
evidence.
is C1 and C2.
Yes.
Are there any objections?
None.
Okay, then they'll be admitted as Exhibit E. I have a question. I mean, does it need to be, in order for their argument is that they didn't require permitting because this was an agricultural structure, and I guess, does it matter whether or not it's classified as agricultural in the PUD or in the property appraiser for them to make that argument?
Legally it does,
And
under the language of the statutes.
which statute? The right to Farm Act?
And the agritourism statute, in order for the building code not to be enforceable.
Okay, and even if it's not enforceable, did you hear Mr. Jones's statement that an application would still need to be filed?
That's what, yes, and I have heard that testimony in previous cases, that somebody is supposed to still come in and say, we're building this farm building, here's the dimensions of it.
Are you aware of what code section in the Land Development Code requires it, or what Florida statute, just so
No,
that I understand?
No, I'm not.
Okay.
Ms. Coutu, are you aware of it?
For what's required, for the form that's required for the building division, Carl, that's your baby.
I'm not going to be able to give you the exact code section, but I believe I want to say, it's in Chapter 1 of the Florida Building Code, where it says that all structures require permits. And I'm giving you the short version. All structures require
Thank you.
permits
Yeah.
unless you get the ag exemption. And then even under the ag exemption, it says that you're not exempt from floodplain regulations and requirements.
I'm familiar with that, yeah.
So what we do is that application, although it's not a building permit application, it's the application where they show to us, this is an ag property, it is an ag building. However, and then we would verify it's not in a special flood hazard area, and we make sure that all the pieces are where they belong. And then, once all that is satisfied, then the exemption is granted. Or we acknowledge that they don't require building permits.
So I wanna separate some of these arguments. So on that point, I'm skeptical that 18-8 subsection A applies. That may be a building code issue, and it may be another code section issue, but I don't think that's an 18-8A issue, because what that section says is no person shall erect, et cetera, any building or structure subject to this code without having first obtained a permit. But I think that would be a different kind of application process than this, because I believe they're right that under the Right to Farm Act, you wouldn't need a permit from the county for that structure. If it was just an agricultural, if it's not what it's being used for now. That's just, I'm going to set that point, just that narrow point aside. I think it still leaves the issue of whether or not this qualifies under the Right to Farm Act. And so I'd like to understand why it doesn't.
Because it's not on land classified as agricultural.
And if I recall, the Right to Farm Act, do you know what the statute is off the top of your head?
I do.
Everyone buckle up. I know this is what you expected, a riveting
It's
Right to Farm
section
Act.
823.14, and I do have copies of the statute.
Okay, would you mind sharing those?
I have several statutes. I have copies for you too.
So, Mr. Drosky, I'm trying to do this so I don't have to continue it or go home and
Yeah.
analyze it. I want to try and get to the bottom of it here.
So in the interest of efficiency,
Yeah.
I mean, I think you nailed it. The violation that was noticed had to do with the code section 18-8A.
That's my point.
So there is no alleged violation of the failure to obtain some sort of zoning clearance or surface water management clearance under the Right to Farm. That's not why we're here. We're here to address the fact that this building is now within the PUD, and it requires a permit, and the permit's been applied for. So in the interest of efficiency, really all we're asking for is a compliance date to get that permit.
Okay, well, that will simplify things.
Yeah.
So what is the county requesting in this case?
That's you.
You want to deprive me of going through all these statutes
It's
and
not,
giving a great
it's
analysis?
not relevant to the violation that's been noticed.
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they received once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
How much time do you think you need to rectify the permit issues and obtain an after-the-fact permit? I understand you may be waiting for the county to give
Yeah,
you
I say some of that's on the county,
give-
but I think a
give me a
60 day,
best guess.
I think a 60-day window is reasonable.
Or do you want to have a confer about that briefly?
Well, yeah.
I'll give you a chance.
So we would be agreeable to 60 days for permit issuance and then another 60 days for CO.
Okay.
So 120 days total to get the CO.
Right, so I have read the code section. I agree it would require enough time to not only obtain the permit, but obtain the CO, as Mr. Jones indicated earlier. Mr. Jones, I'm not putting any obligation on the county here. I can't do that. But what I'm wondering is, assuming the parties pursued it in good faith, do you think 120 days is sufficient?
Actually, I think they're kind of cutting themselves short on time. And I have a few questions because in all fairness, I want to ask them a few questions about the progress. You have a fire system that's going in. How close are you to completion on that fire system and fire sprinklers?
The fire system is very complete. We were held up with the backup generator required a propane tank. Suburban Propane was contracted back in May 23rd, and we just found out last week that their permitting was on Suburban was not correct, and they finally got the permit submitted last week for that tank. That is the last remaining thing for that fire suppression system, so the electrician can come and run that,
Run
and
the
that's what
generator.
we're waiting on.
Yeah, the reason I'm asking this question is because a single permit for the gift shop building, the gift shop restaurant building, is not the only requirement for getting a CO. You have to consider those other ancillary permits that support that permit. So I just want to make sure you guys understand we're going to be looking at fire suppression, fire alarm system, and building permit. So And-
Stormwater's still not resolved engineering-wise, I know.
Stormwater.
Yeah, let me just add, if I can, that we're working, some of these issues, they just kind of want to go on, because we're going to do with other state agencies. I'm not sure exactly who, maybe Dr. Wilburn can fill us in, or Carl Jones, who these agencies are as to, but we can't do stormwater retention. We already got gigantic.
And we don't need to get into the technical aspects of that.
But when you submit something, it takes weeks just to hear back, and then you go, and then before you know it, time does.
So, yeah, we're just trying to nail down a time. So is 180 days more realistic?
Yes.
Okay.
I think that's reasonable and more
All right,
realistic.
in order
considering
to issue this order, I have to either make findings, which would require an analysis, or I think the other side would need to waive the argument and for me to make these findings. In other words, I would give 180 days, and if the thing doesn't have a CO in 180 days, the county has a choice. It could start to fine, or they could use their discretion to look at your good faith and say, we're not going to do anything. But I either have to actually make findings or you have to waive your argument. Does that make sense?
Waive which argument?
In
That there was a
elimination
violation?
order that the property is in violation of this code section, 18-8 subsection A. So I either need to give a reason why that is based on the evidence, or
Well, I don't know that we want to waive anything, but I think a finding that in your discretion, you find a permit is required and hasn't been issued, and that would be a finding to support giving a compliance
well,
deadline.
I mean, do you concede that?
That a permit is required?
Yeah, and hasn't been issued.
We've already applied for the permit, so we're correcting the alleged violation.
I'm wondering if you're conceding that a permit hasn't been issued on this building.
Are we conceding that, yeah, permit has not been
Okay,
issued.
all right.
A permit
So-
has not been issued
Okay, so
on
what
this
I'll
building.
do is I'll issue the order. The property is found in violation. I adopt the county's proposed findings of fact. And 180 days are granted from today, or I should say from the date of the order, to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $150 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first reporting. And the owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Good luck.
Okay, thank you.
Were all the exhibits accepted?
Yes.
Everyone does, thank you.
Next case on the agenda, William Klein and Carissa Gandy, case number 216-4870. Officer on the case, Alan Jonason, page 13 of your agenda. Joanna Cattouse, the expert on the case.
Ms. Gandy? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
My name is Carissa Gandy.
Thank you.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 216-4870, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address of the violation is 4600 East Harvard Drive, Hernando, Florida. Property owner is Klein William and Gandy Carissa. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 18 May 2022, photos taken during my compliance inspection on 17 June 2022, aerial photos showing the shed on the property, and photos of my final inspection conducted on 19 July 2022. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the notice of hearing posted on the property, and a copy of the posting affidavit.
Ms. Gandy, I'd like to ask you to review these documents and let me know if you have any objection to them being evidence in this hearing. And take your time.
So this photo here was just taken a couple days ago. Initially, when he came out to the property, he had posted it on the lot next to ours, not our lot. So we would not have known that this notice was for us. My husband was leaving the house the other day and saw him over near the property and asked him. So that's how we knew about today.
So I think that's a good point. What I would point out to you is that you're not challenging that the photo shows what it shows, but you have comment to make about why it's not really relevant.
Yes.
I mean, would that be fair? You're challenging the notice.
There are other issues, but yes, I did not know about today or to be able to prepare accordingly or anything like that.
Okay. And so what I consider that for the record is a challenge to notice, a challenge to the due process. In other words, you haven't had a chance to prepare. But I don't consider that a challenge to the photo itself because you're not challenging the fact that it shows what it actually shows.
Yeah, it's there.
All right, so I'll admit without objection what's proposed as Exhibits A and B, but I will want to hear your comments on them
Yeah.
after they present their
Okay.
case.
Okay.
Thank you.
Yes, sir. On 18 May 2022, I conducted an initial inspection and observed the property to be in violation. On 18 May 2022, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance listed above. On 17 June 2022, a compliance inspection was conducted with no change to the property. And as of my final inspection on 19 July 2022, the property remains in violation.
Did you hear the comments that were made about where the sign was posted?
I did, yes, sir.
I-
You can see in the picture, the shed is immediately behind the posted notice of hearing. I think it's the second to last article in B.
In B.
Yes, sir.
Well, I see where the shed is in relation to the sign.
And you can also see on the
question
aerial
is-
photo.
The question is the sign posted on the actual property? And so that's what I'm trying to figure out. Do you know if it is actually on the property?
I do, yes, sir.
All right, can you show me where?
Yes, sir.
And I've got Exhibit A, page 4 of 5.
So the road is right out here,
Mm-hmm.
and this utility pole
Mm-hmm.
is right there. The notice of hearing was posted almost directly across from there.
I mean, that's not on the property, though.
It is, because the shed is right there. And if you
But
look,
you look at where the property barrier is. Look, it's the red line. So you're saying you posted it here. It may not be right, but I think it's an interesting point. So let's, have you had contact with the property owner at
I
all?
briefly spoke to the property owner yesterday.
Okay.
While I was taking my follow-up photos, and he admitted to me that they had an issue with the shed, that somebody had dropped it off, and that he understood. He was a little upset, but I spoke to him later on in the day, and he said they would get the necessary permits or whatever they needed in order to abate the violation.
I mean, Ms.
He
Candy,
had
here's
spoken to my husband, but
I'm sorry?
he had spoken to my husband.
Yes.
That's what I infer. But I think I want to address your notice argument first. It looks like you're right to me about where the sign was posted. However, you are here. So
Yes.
how would it change your preparation for the hearing?
Well, he says that he had posted the notice May 18th, which is not where he had told my husband he had posted the notice
Okay.
originally. There is a for sale sign in our neighbor's property, and he said that he had posted it closer to that sign.
My question is, if you had, let's say that you had found out on May 18th about the violation versus a few days ago or even yesterday, how would it have changed your preparation for the hearing today?
Because it's my right to be able to have a due notice of what's going on.
Well, according to
and
case law, if you actually show up at the hearing, you've got notice. So what I'm trying to establish is, how would it have changed your preparation? Would you have found an expert to say that the shed isn't on the property? Would you have found
No, but it would have probably given me a little bit more time to maybe try to get it into compliance before having this hearing. The issues that we have been having in order to be able to get the proper permits for it, and the
Okay.
issues that we had with purchasing it, and there's a whole issue with that. But there have been notices going up all in our neighborhood, and so we've seen notices for, overgrown, not permitted, things like that. So when I saw a notice in the neighboring yard, at no point in time did I think that that was for me. So if it had been posted in my yard, I definitely, because we've gotten notices before hung on the shed. So
Do you know
we
if-
did address those immediately.
Do you know if the property, are you aware of what they're accusing you of?
That I have an unpermitted building on my property.
Sort of, yes.
And this one says illegal structure and construction without a permit.
If I may, previously the building division was out there, and because this was going to be a tiny home, they were
Okay.
going to permit it on that vacant property. I received the case due to the tiny home not following through with the permits.
Yeah.
And so in our case, this is a storage on a vacant because it's a shed.
Yeah, there's no tiny home there, there's a
Right.
shed.
Yeah, well, they were going to convert it into a
I
tiny
gotcha.
home. Yes, sir.
Is there anyone else from the county who wishes to testify on this?
If you want to, Joanne, sure.
Joanna Coutu, land development is a residential lot, Coastal Lakes residential, mobile home allowed, and there is no primary structure at this time.
Has there been an application for
No.
any kind of? Okay.
Not at this time.
We have been having since we had purchased this before COVID shutdowns had happened. And when we purchased it, it took several months for us to get it delivered. We bought it from Doug Doty at Easy Builders. I have known his family for a really long time, and he had told me, I went very specific. I had plans drawn up myself, not engineering plans, but I said, this is our goal. This is what we're wanting to do. We had moved from a large house and was deliberately trying to do something smaller. And he said, absolutely no, that's perfectly fine. We can do that. We can get the permitting. We can help you, do the plumbing and all of these things. And I went in trusting that he was going to be able to help us do that. Months and months and months later, obviously that didn't happen, and we found out that he was not able to do those things. And so when they did eventually come and deliver the shed, we were supposed to have it delivered on the property that we're currently living on, which is, here is our property that I own, and this is where I'm living. So you can actually walk to the backyard
Okay.
of the other one. And they had delivered it here.
Do you want to introduce that into evidence?
Sure.
Do you have a copy?
I mean, you could have it. It's from the government's website.
I just have to be fair. The other side
Yeah.
has to see what you're referring to.
Give it to him.
It's up to the county. Yeah.
So, I can do it. So here is the property that he had posted on, which is
Before I view it, let's let the county look and make sure they don't have any objections to me looking at it.
Looking at this,
So yeah,
is it this one?
what you have is my property. This is the property that the sign is posted
Okay.
on, which is his. I own these two lots here. The county owns this lot and the property down here.
And who owns this one?
Chris Borgens, that's the sign that.
And that's where the shed is?
No. The
Oh,
shed
okay,
is,
show me where the shed is.
The shed is on my property here.
Okay.
This is the lot that the sign is posted on, which
All
is
right.
owned by Chris.
Okay.
I'm just using this.
But the shed is here,
Yeah,
and
it's
you
on my
own this lot too?
These two lots.
Both lots?
But the shed is only on one.
And you said you live somewhere. Where do you live?
Here.
Okay, so it doesn't abut though. Okay, I have no objection, Your Honor.
Okay. What's been proposed then as, let's say, Respondent's Exhibit A is admitted. Okay, so what is this? What am I looking at?
So this is the property that he had posted the sign on, which is owned by Chris Borges. These are my two lots,
Okay.
and this is where I currently live. The county owns this lot and this lot. This is a pond. So when he had initially brought the shed, it is put on this property here, which is county property, this square and this square, and he had put it on the county lot. So we actually had to have someone else move it to be on our property so that it wasn't on your property.
Okay, you're saying you saved the county
Moving fees.
a moving fee and you did a good deed and then
We
created
were
a code
putting-
violation for
yes,
yourself.
We were
Okay.
putting in effort to try to, correct the situation so that we could progress on what we were wanting to do. When COVID shutdowns did happen, obviously a lot of problems came, and since things have started back up, we have called tons of contractors. One of the contractors who was here earlier, we called him, and every single one of them, here's some of them, told either we left messages and never got called back. We've tried multiple times. They said they don't do shed to domicile conversions, or they just said they were too busy with new construction. So no, progress has not been made because we have not been able to do what it is that the county has told us we needed to do.
So
to
let me,
pull the permits.
and I just want to clarify then, so what this code section basically says is that because this is a residential lot, you can't have accessory structures like sheds or have accessory uses like storing things on it unless the principal use is in place, which would be a residence.
Yes.
So the issue here is, it seems pretty clear that there's a violation. The only question is, how long would you need to fix it, either by, I think, converting it or getting permission from the county to convert it into a tiny home? Is that right? Or just removing the shed? What needs to be done to fix this?
Take it off the property or get a permit for it, building permit.
Okay, right.
They can get a permit for the shed if they tie it to their house next door, like a unity of title form, and it can stay a shed rather than conversion, and that might be okay.
next door.
My uncle
not next
owns
door?
the
There's
adjoining
gap?
property.
Is there a gap? Okay.
Yeah, there's
My
a gap.
my uncle owns adjoining
I
property
apologize,
that
I thought there
touches
was.
ours.
That's not enough. Yeah.
Sorry, I was misinformed.
Okay.
No, so they'll have to take it off, remove it somewhere.
Unless the permit they get
Unless they
includes
get
the
a
shed.
permit for, yes, they can get a
Okay.
permit for a primary structure or conversion of the shed, yes.
If there was an adorable kid defense, you'd win automatically.
Yes.
But
Unfortunately.
in any event, how much time do you think you need to fix this?
We have spoken about maybe just trying to sell it, and there's that. But I would like a little bit more time to at least, go back and try to call people again and see if we can get started on it. I would like 90 days.
Yeah, I mean, it would be as simple as removing it too, to be clear.
It's 34 feet long.
Yeah.
And if I remove it, I don't have anywhere to put it.
Okay. What's the county's request?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay. I am going to find the properties in violation. I adopt the county's proposed findings of fact. I will make a finding that although there are concerns with notice and due process, that I will overrule the objection due to the presence of the respondent and the cogent arguments made by respondent. The owner is going to be granted 90 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the owner's real or personal property. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owners will be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a part of the lien.
Thank you.
Thank you.
Thank you.
Next case on the agenda, John William Hex, case number 216-3542. Officer Alan Jonason assigned to the case. Page 20 of your agenda, Joanna Coutu, expert on the case.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Your name, please.
John Hex.
Thank you very much.
Good morning.
Morning.
542.
543.
Okay. Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. I have two cases on two,
Is it two separate addresses?
they are two separate addresses.
Yeah, so
They're side by
we do it
side.
separate.
They're side by, okay. This is case number 216-3542, a violation of Citrus County Land Development Code, Section 4002, site development without development order or permit. Address is 5061 North Emerald Drive, Hernando, Florida. Property owner is Hext John William. I have good service via posting the notice of hearing on the property and posting it to Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on 29 April 2022, and aerial photos taken from the property appraiser's website. Exhibit B, a copy of the notice of violation, notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Mr. Hext, is that how I pronounce it?
Yes, sir.
Can I ask you to look through these documents and let me know if you have any objection to them being evidence?
I haven't seen that, but other than that, it's all good. Oh, somebody took it. Yeah, okay.
Sir, did you have any objection to the photos?
No objection.
Okay.
I can tell my side on it, though.
I'm sorry?
I can tell you about it, though.
Yeah, absolutely. I welcome commentary on it, but I do.
I purchased a I live in
normally,
Marion.
I'm sorry, sir.
Yeah.
Normally, I wait till they
That's just a
present their
picture, that's
side,
fine.
just so I can keep it organized in my
Sure.
head. Without objection, what's been proposed as Exhibits A and B are evidence. Go ahead.
I conducted my initial inspection on 29 April 2022, observed the property had numerous trees removed. While researching the property, I observed that there were no permits applied for or issued, and the aerial photos from the property appraisal summary depicts a large amount of tree cover on the property before the trees were removed. I've had brief contact with the property owner, and as of my final inspection on 19 July 2022, a permit has been applied for.
It has been applied for?
He has applied for a
Okay.
permit, yes, sir.
Is there anyone else from the county who wishes to testify on this?
I haven't done that one yet. I don't have a permit for that.
There's no permit for 5061. I'm sorry, Joanna Coutu, Land Development. Coastal Lakes residential lot should be vacant, should not have trees removed. There was a permit applied for in the internet system late on the 18th, July 18th. It's so recent I can't see the plans to know if it encompasses both lots. It actually was tied to the other address, 5065, but he may have planned on both permits. It's too new for me to view.
Let's find out. Mr. Hext.
I got permit numbers on all sides.
Okay, so it is, I think let's
So
first
what I
things,
did is I bought the property.
first things first, I'm sorry. You heard the question. I want to work backwards if I can. So does the permit that you applied for, permits you applied for, does it encompass this property located
Yes.
at 5061?
Yes.
All right, now I'd welcome your comments.
Well, it's really not much. I mean, I bought the property. I had house plans being worked with engineering. I called here and talked to whoever, you know. I never asked about trees. I didn't even think about trees. It's where the house was going to be. If you can look, but there's numerous ones that were rotted, were falling into the neighbors. The other neighbor, I think, that actually has a complaint, or did the complaint, there's two that's actually fixing to fall on his property that need to be coming down. And thought I was doing the right thing, did the wrong thing. Just wanted to put a house in.
Okay, and so it's your representation the county doesn't have anything to really contradict that you've sought a permit to
Right.
put something there. Let me just ask the county, on the permit application, does it need to include the removal of the trees that are now down in order to satisfy the county?
No. I mean, the tree removal is part of a permit, but there's no way to retroactively after the fact permit.
Well, right.
Right.
I understand.
So it would, if they weren't removed, we would have it as part of the house permit once it's issued.
That's what I mean.
Right.
Yeah.
Okay.
And it's my fault. I'm not saying that. I live in Marion County, and we don't have to do that over there.
I saw Summerfield.
Yes. And we don't, you can just cut a tree down and build your house.
I wouldn't be so sure about that.
Well, that's how it's always
having
has
dealt with
been.
Marion County.
Yeah.
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 Yeah, they have
Well,
quite
I
a few
mean,
ordinances on
a
this.
lot of it, yes.
So I guess what I will, what does the county need to see to abate the violation? The permit to be issued?
Well, it has to be completed. So the permit can be issued, but we will keep the case open until the permit either expires or it's certified as closed.
Meaning that it's been finalized?
Yeah, absolutely, finalized.
If the permit's issued,
That abates it. That's what I thought. Okay. So how much time do you think you need, Mr. Hext? Well, I don't know. I mean, is this a complicated plan?
No.
What are you building there?
It's all done. The plans, all the engineering's done. Everything's turned in.
How big is the house that you're building there?
I think it's 1,400 square feet.
Okay.
Small, little 1752.
Okay.
And there was a pole barn too. And both of those were engineered and turned in also.
I am going to find that the property's in violation, and I will grant 90 days from today to abate the violation. I think that's more than enough time probably to sort out permit issuance, but there may be problems with your application, so those should be sorted out expeditiously. You've got 90 days.
Okay.
And I'm sorry, what's the county's recommendation?
Due to the nature of the violation, the Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $200 per day along with the administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
If the violation is not brought into compliance as ordered, a penalty of $200 per day will be imposed. This fine will be recorded and will constitute a lien on the owner's real or personal property. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
So that's if the permit doesn't get it
If it's not issued in 90 days.
in 90 days?
Yep.
Okay. All right. So if I'm waiting on them in 90 days, what happens?
That's a good question. Yeah, I would work it out with the county.
Okay. All right.
Thank you.
Yep.
Next
Thank you.
case, John William Hex, case number 216-3543. Code officer on the case, Alan Jonason. Page 21 of your agenda, Joanna Coutu, expert on the case.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 216-3543, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. Address is 5065 North Emerald Drive, Hernando, Florida. Property owner is Hex John William. I have good service via posting the notice of hearing on the property and posting at the LaCanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 29 April 2022, aerial photos taken from the property appraiser's website. Exhibit B, a copy of the notice of violation, notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Sir, I'd like to just
Same
ask you.
thing.
Okay. No objection?
No, sir.
All right.
Same thing.
Without objection, what's been proposed as exhibits A and B are admitted. Mr. Jonason, are you going to simply testify to the same thing from the prior case? I'm going to reincorporate, unless you have any objection,
No,
Mr.
sir.
Hex, the
No, sir.
testimony from case number 216-3542 into this hearing. These are contiguous parcels, correct?
Yes, sir.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $200 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owner once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Mr. Hext, are you building on both properties, or is what you submitted going to cover both parcels?
Well, that's what I was asking too, was the other day, was do I have to make it into one lot, or how that's gonna work?
Well,
as
what's
far
your
as the-
intention? It's a 1,700 square foot house.
One lot.
Okay, so it's your intention just to
Yes.
build one house on two
Yes.
lots?
Yep.
Okay, so that's what your plans show, is that it covers both lots?
Yep.
Does the county think this needs to be addressed in any way?
Yeah. You also said a pole barn. Is that on the other lot?
Yes, ma'am.
Okay, so he can do a unity of title with the two properties to tie them together and allow the pole barn on one, and that covers it. That will
Okay.
cover the tree removal for both cases.
Okay, great.
But that requires him to apply for it, right?
He has applied for
Oh,
a
he
permit
has,
for,
okay.
for two structures, a house, and I can see there's a house and a detached structure. I just can't see where they are yet. It's
Got
very,
it.
very soon.
All right, so it covers both properties. I will find that the property is in violation. I'll grant 90 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $200 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Mr. Hext. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county law, which may also be filed as a lien of record. Good luck.
Thank you.
Okay, thank you.
Next case on the agenda, Anthony W. Dabney Senior, case number 2164662. Alan Jonathan, officer on the case, page 15 of your agenda.
Morning.
Good morning.
Mr. Dabney, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name for the record?
Anthony Wayne Dabney Sr.
Thank you, sir.
Good morning. Alan Jonathan, Citrus County Code Compliance Officer. This is case number 2164662, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 2415 North Creedy Avenue, Crystal River, Florida. Property owner is Dabney Anthony W. Sr. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 16 May 2022, photos from a compliance inspection on 29 June 2022, and photos of my final inspection conducted on 19 July 2022. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Mr. Dabney, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this case.
No, sir, I do not.
Okay.
Goodness gracious, what did you stick these together? Thank you.
Without objection, what's been proposed as exhibits A and B are evidence.
On 16 May 2022, I conducted an initial inspection and observed the property to be in violation. On 16 May 2022, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On 29 June 2022, I conducted a compliance inspection and observed that the property remained in violation. I have had contact with the property owner, and as of my final inspection on 19 July 2022, the property remains in violation, although he has made incredible progress towards abating the
I was
violation.
going to say, I feel like I see a lot of improvement in the photos.
He's been
Mr.
working very hard.
Mr. Dabney, what's your stance on this?
I spoke with Mr. Johansson, I guess, a couple of weeks ago, and I had explained my situation, that I had been injured and that I was unable to work on the property myself. I had a couple of people that had pledged themselves to help me, and the day that I spoke with Mr. Johansson, I hope I'm saying that name right, but the day after, I lost my helpers. But I've still been working on the property with the help of a neighbor, and we're just about one of the vehicles in question. I finally was able to get in contact with the owner to have them come and get it, rather than me just get rid of it. And the rest of the items we're working on a daily basis right now.
How much time do you think you need to bring the property into compliance?
I would say, considering that I'd probably be doing it by myself, about 60 days. I can have it done within that.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with the administrative costs, to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. Mr. Dabney, you have 90 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on your real or personal property if it comes to that. I grant 90 instead of the 60 because you've already made such improvement. You're working with the county, so that shows good faith. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And Mr. Dabney, you would be responsible to pay all costs required by county law, which may also be filed as lien of record if it isn't brought into compliance within those 90 days. That's it.
Thank you.
Thank you.
Yep.
Next case on the agenda, Farah J. Smith and Lisa Doreen Ennis under trust agreement of Talmadge. Case number 216-5865, page 26 of your agenda, Officer J.C. Charlton.
Okay, the name is individual Lisa Ennis, it's Kathleen Silverns.
I understand, but
Okay.
you're here on, that's who owns the property. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ma'am, please state your name.
Kathy Lee Silverns.
Thank you.
Good morning.
Good morning.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 216-5865, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5392 West Bandy Lane, Dunellen, Florida. Property owners Thera J. Smith, Lisa Doreen Ennis, and trust agreement of Talisman Smith, June 1st, 1988. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during my initial inspection on June 8th and corrective action inspection on June 17th, and photos of my final inspection on July 17th, all of 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and copy of the signed certified mail return receipt.
Jesse, the last inspection date was?
I heard the 17th?
Yeah, I think it was the 19th.
July 19th.
Oh, okay. Ma'am, I'd like to ask you to take a look at the documents you're about to be shown and let me know if you have any objection to them being evidence in this hearing.
Well, I don't have an objection.
Oh.
I'm purchasing the property from Lisa Ennis in the trust.
Okay.
That's why I'm here.
I see. So you don't care
I
what...
never received any of the paperwork.
Well, you're a prospective purchaser, not an owner, right?
Right.
Okay.
Exactly.
So you don't
But
need to
I'm
look at the
living-
photos.
And
Okay.
that's not even, this is a second property. My son-in-law is over there. But they never made me aware of anything.
The current owners didn't?
Right.
Okay.
They didn't tell me
Oh.
they had it. I know it's in violation. I don't,
Okay.
You know what I mean?
All right,
I don't,
yeah.
You know.
Well, all right, so you don't have any
I
objection
really-
to these photos per
No,
se? Okay,
no.
all right,
No, he's definitely not wrong. You're welcome.
okay. Ms. Barrows, have I missed anyone from the public who wish to speak on any of the other cases that you know of?
I think you might have.
Okay. Okay, just curious. All right, so without objection, what's been proposed as Exhibits A and B are evidence, and please proceed.
All right. On June 8th of 2022, I conducted initial inspection and observed scrap metal, household garbage, and debris on the property. I've had no contact with the owners. I've had contact with Kathy. She made contact with me in regards to the violation and stated that they would work on getting the debris removed from the property. As my final inspection on July 19th of 2022, the property remains in violation.
Well, ma'am, it's not your responsibility, it sounds like, but what's going on?
Well, it was just a matter of getting my son-in-law, who's going through a divorce with my daughter, this is like a whole saga, I'm sorry, to even just believe me, because he's like, that's my scrap metal, so he's tarped, it's on a trailer, so he's tarped the trailer. The truck bed, he has filled with all the rest of the debris, and I have somebody coming Thursday to look at what they're gonna need to pull all the rest of the stuff out of there. I had to hire somebody. I've had other people that I've been trying to get to the property, but they never show up. I don't know.
When is your closing on the property?
There isn't a specific closing because I'm just like a rent to own. It's private sale, and that one property I'm wanting to turn back over because he hasn't been paying
Oh,
his
they're
rent. So my son-in-law, I started purchasing it because my daughter was pregnant. They needed a place to go. So the people that were in the house had passed away, so Lisa offered it to me. So I said yes, but I talked to the kids. I said, you guys have got to pay the rent because the rent was the mortgage. I wasn't asking anything else from them except fix what breaks, keep it clean, da-da-da-da-da. And that's what I have. Like foreclosing basically on that property. I'm turning it back
You're
over.
foreclosing.
Well, I have to turn it back over. I haven't been able to pay on it since they've stopped paying.
I understand.
Yeah.
Okay.
Yeah.
Is there anyone else from the public who wishes to be heard on this case? Ma'am, as best as you know, how much time do you think everyone's going to need to fix this if there is an intention to fix it?
Personally, I would probably just need another 30 days to I have one person, like I said, coming out on Thursday night to see what they're going to need to pull the boat, but he's like, that's my project boat. It's like, I'm just getting an argument, so I need the time, so
Yeah.
when he's not home, I can just have people come in and clear it out.
What is the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
I do adopt the county's proposed findings of fact. The property is found in violation. I'll grant 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owners shall be responsible to pay all costs required by county law, which may also be filed as a lien of record. Thank you.
Thank you.
Thank you.
Next case on the agenda, Wayne Wilkinson, case number 2163963, Code Officer Amy Becker, page 33 of your agenda. Expert on the case, Carl Jones.
So I see an expert listed on page 34, but not 33. Is that?
Just a junkie.
Okay, all right.
35 is a junk, okay.
Are you presenting them all at once or just?
I can present them all at once if you want.
I prefer them to be,
Okay.
yeah.
Just a case.
Case number 2163964, and case number 2163698.
Do you swear to tell them? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, sir.
Wayne Wilkinson.
Thank you very much.
Good morning, sir.
Good morning.
Good morning.
Good morning.
Amy Becker, Code Compliance Division. Case number 2163964, violation of the Citrus County Land Development Code, Section 2406, Medium Density Residential District, MDR. Case number 2163963, after the fact permit shipping container, or violation of the Citrus County Code of Ordinances, Chapter 18, Article 1, Section 18-8A. Case number 2163698, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address of all three violations is 3 West Lemon Street, Beverly Hills. The property address for all three cases is Wayne Wilkinson. I have good service for all three cases via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence for case 2163964, case 2163963, and case 2163698. Photos taken during my initial inspection on May 3rd, photos taken on June 14th, and photos taken on my final inspection July 19th, 2022.
And are those photos the same for all three cases, or are there different sets of photos?
There's different sets of photos.
Okay.
But it's not going to be so different.
Right.
I didn't know we'd hear them all at
But
the same
that would be
time.
Exhibit A in all three cases, correct? The photos?
Yes.
So, Mr. Wilkinson, I would like to ask you to review all of what's been proposed as Exhibit A in these three cases, and just let me know if you have any objection to them being evidence in these cases.
Okay.
Take your time. I think, just so the county knows while we're waiting, I think right now my questions are going to be concerned with the application of 2406, LDC 2406, and its requirements, and which requirements in that code section have been violated.
Okay. And I have an expert witness of Joannica too.
I believe you do.
And then I'm also going to note that the property is zoned MDR, medium density residential. Okay, just so you know. Thank you.
Mr. Wilkinson, did you have any objection to any of those photos?
No, sir.
Okay.
On May 3rd, I conducted
I'm sorry, ma'am. And so you still had, did you also show Exhibit B for all those cases?
Yes, I'm sorry.
Okay, I didn't realize that.
No, my mistake. I'll finish that up and I apologize.
Thanks.
Exhibit B, for all 3 cases, Exhibit B, a copy of the notice of violations, a copy of the notice of hearings, and a copy of the signed certified mail return receipt for the 3 cases signed for on June 30th, 2022.
And those were all reviewed by Mr. Wilkinson?
Correct.
Okay. And you didn't have any objection to any of these documents?
No.
All right, then what's been proposed as Exhibits A and B in all 3 cases are admitted as evidence.
On May 3rd, I conducted my initial inspection and observed a thrift store with signage that stated store to open, donation drop-off, Monday through Saturday, 9 to 4, and truck with signage, church youth thrift. I observed an appliance in front of the structure along with a couch, and it appeared open for business. I also observed a mattress, chairs, and an appliance as far as the junkyard condition complaint. And I also observed a shipping container. When I got back to the office and I checked Hanson, I showed that there was no permit for a shipping container for the property. So on May 3rd, I spoke with Mr. Wilkinson and advised him he would need to have a conditional use permit to have the business in the MDR, and I have an expert witness here to testify.
Trinity Land Development, it's medium-density residential. They are doing a retail store as the primary use there. I've spoken with Mr. Wilkinson, given him the conditional use application. That pod out in front, which is another complaint, cannot stay, but he thinks he might have a place on there that can be screened from public view completely. That would be after a conditional use approval. We don't have an application at this time.
So I'm looking at the MDR zoning, and I just want to find where it is on here. Where would be the conditional use?
Can I approach?
Yeah, please. Sorry, it's just.
No, I don't have it memorized,
Is
so.
it neighborhood commercial?
It's actually neighborhood commercial, small retail shop, possible strip center.
Okay.
And then we have, here's the office use. So we would let it fall under something like small retail shop with conditional use.
Okay. So in order for him to abate the violation from the county's perspective, it would be to obtain, well, for this violation at any rate, the MDR.
For the use violation, he would need the conditional use approval, yes.
Okay. Okay.
We still have the pod, that's another complaint.
I see. May I see some photos? Whenever you.
This is the conditional use case.
No, it's that one.
Oh, sorry.
That's the conditional use
No,
case.
This is the conditional.
Okay.
That's the pod one. The other one's the junk one.
I'll take them all and
Sort them out.
I'll absorb it.
I apologize for that.
I will survive. Thank you. Just one moment. Ms. Becker? Yeah. So when you had contact on May 3rd, what was the nature of the conversation you had?
The nature of the conversation was, I told him that he would need to have a conditional use in order to have the business. And Mr. Wilkinson did come in on May 26th, and he spoke with Joanna Catu in reference to the conditional, to get the paperwork that was necessary.
Okay. So that would address, I guess, one of the cases, but if he got a conditional use, would that address the junkyard conditions? Because I see a lot of stuff that would be sold as part of the thrift, so would that eliminate that case as well?
That would eliminate the junkyard condition case. The concern I had with the junkyard condition case was with the weather, the way that it's been in the rain we've had every afternoon. He had mattresses and box springs out there, and once they get wet, then there's animals, and then it becomes something different. And there was a damaged couch that was on the property. But I'm assuming when he opens his business that shipping container is that he's going to use that as far as his furniture and stuff to store it in. That would be my thought. I don't know if that's what's going to happen, but hence, yes, you're correct. The junk could. Oh, I'm sorry. Let me.
The expert disagrees.
Yes,
So,
I apologize, Joanna could too. If the conditional use approved outdoor sales area, they would have to come in and out every night. It's not a zoning where you can constantly have outdoor sales out there. So if he had that outdoor sales area in the conditional use, he'd have to bring them in and take them out, bring them in the residential area. You cannot store outdoor sales permanently out there. It's not a thing. I'm doing a retail store. It's not like a Home Depot with the nursery type thing.
So you're saying it wouldn't be sufficient to store it under an enclosed tarp area?
Correct. It would have to come in and out every day if it was part of the conditional use. Outdoor sales was allowed. So even having it there, it would have to come and go.
I'm assuming that the section 18-8A case relates to the pod.
Correct.
Okay, so the only violation under 18-8A is the pod?
Correct.
Okay. Well, Mr. Wilkinson, I just wanted to ask all those questions so that I understand what the county is saying about you.
Sure.
And I want to hear your version of this and what's going on.
Well, first of all, when we purchased the property, we purchased it from a realtor. She assured us that it was zoned commercially and had verification. And I've seen a lot of paperwork from other agents, other parts of the county, primarily property appraisers, that show it as commercial even currently. So we had a lot of confusion, and I purchased the property personally because it was the mortgage was a personal thing. But we purchased it for the purpose of putting the church thrift store there, with the understanding that it was commercial. Also, there was a tremendous amount of work that needed to be done inside that building, which we were not aware of how bad it was, and it took us about 3 months to really get it straightened out. It's about there now. We can assure that the outside would be cleared. Also, we have a dump trailer there because with a thrift store you get a lot of things that you do have to take to the dump. I'm currently working on putting that behind the fence. Right now it is visible from the road, but that'll be hidden. And we've put something up to screen in the pod from the road. And we're working on even some plants and things, some landscaping there to help with that. But also the application for conditional use was filled out, is filled out. There was another provision where we need to have a drawing of the property, and I really didn't know what to do with that. I was having trouble finding one that was scale, and we're not changing anything other than the pod. We're not moving anything else having to do with the property or adding on, or nothing changing the property itself or the buildings there.
But you are moving the pod.
Well, we can. I'm hoping we do have it screened in so it's not visible, and it will be even better. I don't know.
Well, one of your, I mean, it seems under just talking about the 18-8A case is that I believe you can get an after-the-fact permit, but I don't know if that's at issue here or not, or if the county would even entertain it.
I'd like to check with council regarding that.
Yeah, sure.
That would be after, for which part?
Yeah.
That's right. Sorry.
I translated. That was okay.
Thank you.
Yeah.
But you need a permit, not just for the pod, but for the building. You're gonna need to claim that then. Can you make that clear?
Change of occupancy and for whatever has been moved on the property from the structures.
Okay, so he could, pending the conditional use, He could get a permit for the shipping container. He would also need to get a change of occupancy through the building division.
Okay. Does that make sense to you, Mr. Wilkinson? In other words, in order to get out of 2 of these cases, in order to abate 2 of the violations, namely the 18-8A case, which says that you got a pod there without permission.
Right.
And in order to fix the 2406 MDR case, what that means is the residential use where you need a conditional use approved by the county for what you're doing. In order to get out of those 2 cases, you do need to have the conditional use permit issued by the county, and you would need 2 other things. You would need the permit for the pod and a change of occupancy. So it's a couple steps you'd have to go to fix this.
Right.
Okay? That's what the county's testified to. Does that make sense? I want to make sure
Yeah.
you understand.
It does. I'm a little confused about the part about, because that was not used as a residence except for as a very short time right before we bought it.
And it may have been in
There
violation
were
then.
businesses there.
It may have been in violation then. I don't know. The only
Yeah.
thing I know is what's before us now.
Right.
Maybe you have a cause of action against your realtor for misrepresenting something. I don't know that.
Well, there were businesses there for 20
Okay.
years.
Right.
But if we have to go through those things, then we have to go through those things.
That's what the county is saying. And
Right.
I agree with them according to the laws that are written here. That still wouldn't fix the junkyard condition, so to speak. You heard what they said.
I think that's taken care of. Other than
Okay.
if you're concerned about the tarped area, but the rest of it I think is taken care of.
But you understand what needs to be done in order to take care of it, whether it has been or
Yes.
whether it is or it
Yes.
isn't. Is there anyone from the public who wishes to be heard on this case? Okay. What's the county's recommendation?
The county's recommendation on all 3 cases, case 216-3964, case 216-3963, and case 216-3698. The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day for each case, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it is respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I don't know how long it normally takes to go through a conditional use permit process here in the county. And of course, it's always dependent on what's submitted and is it complete. But assuming that a complete application with no defects was filed today, how long does it normally take to go through that process?
We would schedule them for early October. Early October would be the hearing date.
So
And
we're
we would go
talking-
ahead and schedule it whether it's incomplete or not. With code compliance, we just move forward and go.
So we're talking 120 days?
Yes. Well, 90 anyway.
Yeah. Okay. All right. Thank you. Okay. Mr. Wilkinson, do you have anything else to say?
No, I don't think so.
Okay. I am going to find the property in violation in all 3 cases. I'm going to have a slightly different order for one of them. On case number 2163698, the junkyard conditions case, I will grant 30 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owner. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from date of first recording. On the other 2 cases, 216-3964, 216-3963, I'll grant 120 days from today to abate the violation in each. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. That applies to each case. This fine will be recorded and will constitute lien on the real or personal property of the owner. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And in all three cases, the owner shall be responsible to pay all costs required by county law, which may also be filed as a lien of record. Does that make sense, Mr. Wilkinson?
Yes, sir.
Okay, thank you.
Thank you.
Next case is on the agenda, Daniel J. Hall, case numbers 216-2910, 216-3423, Code Officer Matt Hampton on the case, pages 18 and 19 on your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record, sir.
Yes, sir. Your name.
Daniel Hall.
Thank you, sir. Good morning. Good morning.
Good morning. Matt Hampton, Citrus County Code Compliance Officer. His case, two cases. Case number 216-2910, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of Citrus County Code of Ordinances. And case number 216-3423, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 5511 West Irving Court, Homosassa, Florida. Property owner is Hall Daniel J. I have good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A for both cases will be of photos I took during my initial inspection, April 20th, 2022. Photos I took during my corrective action inspection on June 14th, 2022, and photos I took during my final inspection, July 19th, 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a picture of the notice of hearing posted at the property, and a copy of the posting affidavit I completed on July 6th, 2022.
Okay. Is it the same Exhibit A for both cases and the same Exhibit B?
They each case has A and B,
Yep.
but there are some different
Okay.
pictures
Great.
for each.
Thank you. Mr. Hall, I'd like to ask you to review these documents and let me know if you have any objection to them.
We'll discuss that when we get there. Need you to verify the signature of your property if you have any objections.
Sir, do you have any objection to those documents?
No, they look pretty accurate.
Okay, thank you, sir. Without objection, what's been proposed as Exhibits A and B in each case are admitted. Is there anyone from the public who's going to want to be heard on this case? Okay. Oh, there's someone? Okay, thank you. I'll eventually, I just need to know, so I'll call you up later.
Yeah, I can add something.
I got you. All right, thank you. Please proceed.
I conducted my initial inspection April 20th, 2022, and observed the property to be in violation of the ordinance listed above. For the junkyard case, which is the 2162910, I observed a recliner in the backyard and what appeared to be a detached bumper on the back patio. For the lawn, I observed the grass and weeds to be in excess of 18 inches. There are in excess of the 18-inch maximum allowed by county ordinance. I used a measuring stake to verify. I have had contact with the gentleman, now knowing that it was Mr. Hall in the on initial inspection. He was not very pleased that I was there and asked me to leave. I conducted my corrective action inspection June 14, 2022. There was no change to the property for either violation. I conducted my final inspection on July 19, 2022, and again observed no change other than the grass and weeds have grown even taller.
Give me 1 second. I'm just looking at the code section. Okay, so in looking at the, I think the unkempt lawn photos are pretty clear to me. In the junkyard conditions case, I guess I'm trying to drill down into the junkyard conditions, and I see that it appears to be kind of an discarded sort of recliner of some kind. Is that right?
Yes, sir.
Yes, it was a recliner from a lazy boy recliner from my living room. The legs broke,
Okay.
and one of the arms was breaking, and a friend of mine brought me another one that somebody was getting rid of. It was in better condition, so I had that same friend drag the old broken one into the backyard.
But you can't use that anymore, can you?
If I want to sit in a red chair, I could, yes. I just can't put the legs up.
I advise you not to. That's a, well, it's your own liability, isn't it? But it doesn't.
I'm
It's
sorry,
not.
what?
It's not usable in the way that, you know.
It's not in the safest condition.
I got you. Okay. Mr. Hampton, is that your main concern on the junkyard conditions?
Yes, sir.
Okay.
That and there looks on the corner of the back corner of the property on the patio area. There looks to be a detached bumper, car bumper, or something like that. But the main focus is the recliner.
And that one picture shows the weeds from up the side of the house by the meter. Those have been taken down already.
I guess I'll ask you, Mr. Hall, about the bumper. Is that a bumper? What's going on at the corner of the patio?
There used to be a bumper skin. It's like a rubber skin that goes over the metal bumper.
Okay.
Because I sometimes collect metal to bring in. I'm on Social Security disability. I don't make a whole lot of money. And like all the black cans on the back porch, there's no household garbage at all.
Right.
It's all cans.
Yeah.
The metal bumper I discarded for metal, but they don't take the rubber part because they don't recycle rubber. But all the rest that's piled up in the patio, you saw in the picture, that is all actual patio furniture. Patio table, patio chair, patio bar.
I don't think that's junkyard. I agree with you. I'd like to hear from the public if there is someone who wants to be heard. Sir, did you indicate you wanted to contribute something on the case?
No, I just wanted, if Danny didn't explain everything correctly, I was just gonna intervene.
Okay, so you have nothing to contribute?
Not as a negative, no.
Oh, just one way or the other. I'm just curious if you have any input. And if you did, I would need your name and you'd need to swear an oath.
Yeah, I'll be joking.
No, it's up to you, sir.
Oh. I was just gonna make, I just want to let everybody know that the reason the recliner's outside is because I'm the one that gave
Sir,
them the chair.
I need to have you, if you are going to speak, just swear an oath to tell the truth. Give us your name.
Can you stand, please, sir?
I'm sorry. You came all this way, sir, so I appreciate the input.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you please state your name?
Tom Seco.
Can you spell the last name?
S-E-E-K-O.
Thank you.
Thank you. If you could come over here and just, what would you like to, what should I know about this?
Oh, I mean, it's probably irrelevant, you know, because it's just a couple things in the yard. But yeah, the recliner was going to get removed, and he has the cans. And when he initially got told about the situation, he wasn't really clear on when it had to be done by. He didn't get the mail because he's disabled. He didn't get out to his mailbox. And I'm the one that found the stake in the yard when I came over to visit him with the notice. He's making preparations to get a U-Haul to get all this. He has quite a bit. So
It doesn't look like that much in the photos.
it's quite a bit.
Okay.
Yeah,
Okay.
It's actually going to
Okay.
make about 4 times what the U-Haul is going to cost
Okay.
to get it there. And at that same time, that's when the recliner's going to go and that
Okay.
one rubber bumper.
Okay. All right.
Anyway, I'm trying to help him out to get the truck, and hopefully within the next couple of weeks I can do that.
How much time do y'all think you need to clean up the property and also, I guess, mow the lawn? I mean, kind of.
Yeah, basically he has a riding mower that he usually uses, but that broke a couple months back. So we're trying desperately to get somebody to come, but it's just almost impossible. You call people, they say, "Well, wait, I'll be there Friday." They just never show up. You know. So.
My biggest concern is with the cans, because a lot of the bags I picked up and moved, the bags broke open. They'll be out in the sun and the rain, but plastic bags disintegrate.
Sure.
So now we got to get
Every
someone
time I
to help
pick a
clean
bag
it.
up, everything spills out of it. And with my health issues, I can't be out there picking up one can at a time, putting it in another bag.
Well, I'll be candid with you. The unkempt lawn is very clear, but doesn't require much. I mean, I understand it's difficult to find a professional sometimes, but
Yeah.
I don't think you need a professional for it either.
Well, to get the lawn cut, I do, because my mower is broken, and it costs
There's-
several thousand to fix it. I can't do it.
Back in my day, and granted that was many years ago, there were kids who would do it for $10-15. Now prices have inflated, I know, but that's why
I can't find.
I don't
anyone.
encourage child labor. To be clear, I'm just indicating you don't necessarily need a professional.
It was a 16-year-old.
Okay.
And the parents came over yelling and bitching and screaming at me because I had the audacity
Yeah.
to talk to their child.
Right.
And offer him part-time work in the summer.
Right. I hear you. I hear you.
I was with the court over that. You asked him, he was the witness.
Well, so we're learning a lot about society this morning, and on the junkyard conditions case, you're telling me there's more than I see. I mean, I see a chair and a bumper. So from my perspective, there's not a lot to be done. And the reason why I'm asking is because I'm going to find that the property's in violation, but I want to give you a reasonable amount of time to fix this. I just don't know why it would take more than 60 days. Do you?
60 is very
Yes.
fair.
I can't. What?
You said 60, right?
Yeah, 60.
60 days.
Either you can
That-
find someone to come in to discuss.
Yes, it's 60, absolutely, yeah. I mean,
What's the
at this situation you're in now, yeah.
All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violations. This amount is appropriate given the severity of the violations and the respondent's actions relative to the violation. We would also ask the special master additionally find it as a respondent's responsibility to contact the Code of Compliance Division when the violations have abated in order to allow for reinspection.
You've heard it a lot by now today, having sat through all the other hearings. The property is in violation. I adopt the county's proposed findings of fact. In each case, you'll be granted 60 days from today to abate the violation, and if the violation is not brought in compliance as ordered, in either case, a penalty of $100 per day will be imposed for each case. Okay, so there's 100 if this one isn't done. There's 100 in the other case if it's not done.
That's 60 days per case?
You're correct. It's not aggregate. It's not 120 total. It's 60 in each to get it done.
Okay. So that's 60 if both done.
Oh, correct. This fine will be recorded and will constitute a lien on your real or personal property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law, which may also be filed as a lien of record. Thank you.
Thank you.
Yep.
May I say one more thing?
Yes.
I would like to apologize to you, sir. I did have an attitude till you showed up. I was in a lot of pain that day, and I just did not want to deal with what I knew was coming. I do apologize.
I appreciate that, sir.
Thank you, sir.
Next case on the agenda, Clear Card Holder, LLC. Case number 2164933, Code Officer Alan Jonason. Page 12 of your agenda.
Good morning.
Good morning.
Mr. Gilbert, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your name for the record.
Ian Jobert,
Thank you very much.
How do I spell that last name, sir?
Joub as in boy, E-R-T.
Thank you.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2164933, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 4535 North Remington Terrace, Hernando, Florida. Property owner is Clear Card Holder, LLC. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 24 May 2022, photos from a compliance inspection on 23 June 2022, and photos of my final inspection conducted on 19 July 2022. Exhibit B, a copy of the notice of violation for the registered agent and LLC, a copy of the notice of hearing for the registered agent and the LLC, a copy of the SunBiz, and a copy of the signed certified mail receipt from the registered agent.
Mr. Joubert, I would like to ask you to review these documents and let me know if you have any objection to them being evidence in this hearing.
No objection.
Okay, thank you, sir.
Thank you.
Is there anyone from the public who's going to want to be heard on this case? Let the record reflect that there is no response. Without objection, what's been proposed as Exhibits A and B are evidence. Thank you.
On 24 May 2022, I conducted an initial inspection and observed the property to be in violation. On 24 May 2022, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On 23 June 2022, I conducted a compliance inspection and observed the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 19 July 2022, the property remains in violation.
Mr. Joubert, what's going on? And what's your relationship to the LLC? Are you the owner or the
Authorized member.
Authorized member, okay, thanks.
Yes. First of all, on a timing thing, these mailings go sometimes here to Florida, then out to Wyoming, then to Las Vegas, and then to me. So I don't always receive things in a timely manner.
And I will note that it says on the Sunbiz that the authorized member is Caprese?
Yes, Caprese.
How do I?
Caprese.
Caprese LLC, and it has an address in Cheyenne, Wyoming.
Yes.
So, okay.
I went out, I believe it was 2 days ago, to look at this. I've only been aware of it for a very short period of time at this point. I had gone out there, observed the debris. There's no question that that debris is there. I took the legal description of the property and did some measurements and shot a laser across the mining pit there, and that debris is not actually on my property. That is on the neighbor's property.
Okay.
I would also add that, you know, if it was a matter of a couple of bags of garbage, I'd have gone over there and picked it up and got rid of it just to get rid of this problem. I probably spend $8,000 to $10,000 a year at the Citrus County dump hauling junk from various rental properties I own. That's no exaggeration.
Well, that's the life you chose.
Yes. I am not sure who is going to be found liable for this. If code enforcement has a survey and they can say that, you know, some of this has come over the edge onto my property, then I will get it cleaned up. If it's found that I need to get some of this cleaned up, I would like to point out that this is an old dolomite mining pit. They did this mining up and down the 41 corridor 100 years or so ago. It is, in my estimation, between 75 and 100 feet deep, and the walls on it are in excess of a 45-degree angle. I'd guess close to 60 degrees. There is no walking up and down these walls into that pit.
Safely.
Safely. If I was tasked with cleaning this up, I would suggest it would take at least a year to do. I would have to pull permits. I'd have to spend tens of thousands of dollars building a road down into this property to access this garbage to try and remove it and bring it back up. There's no way to set up a crane to get a crane down in there. It is too deep to reach down in there with an excavator, at least from the property that we control. This property next door was obviously dumping it from their edge of the pit, and it's, you know, sliding down there, but there's no guarantee that they would allow me access on their property to reach down there and get this debris. And also, that dolomite tends to hold water at the bottom. So during the rainy season, there is water down there. I have no idea how deep it is because I can't get down there in the bottom of the pit. Back to the, you know, allowable time to do this. In wintertime, the dry season, I've seen it dry down in there before. You know, so whoever ends up having to clean this, it doesn't seem unreasonable to give that sort of time frame. So it's an undertaking.
Can you explain a little bit more about the laser method you used to determine where the border was on the property? And I'm going to ask the same question to the county.
The legal description of the property, go out there and, you know, measure things off. And
I know how to read a legal description, but I guess what I'm wondering is...
I wasn't able to find the actual monuments or corner markers, but taking the measurement and then just taking a laser pointer and pointing over to where the other one is.
I see.
And this stuff is sliding down the hill on this other person's property, but I don't feel it has made it to the bottom of the pit, you know, and what's actually on the property that we control.
Okay. And so, I guess you're testifying that, and well, first of all, is the legal description meets and bounds? It's not platted or anything? I assume it's meets. Does that make sense to you?
No,
you
I don't
mentioned
understand.
okay, no big deal. And then you're saying that you own the bottom of the pit, basically? Or a part of it?
Yes, a part of it. And I'm not sure how this flies, but this is the property appraiser with the...
I see, okay. And I can't, unless you're willing to introduce your laptop and evidence,
Well,
which I discourage.
everybody can take a look
I
at
discourage
it.
you from doing it because I have to keep it.
Yes. I didn't understand protocol.
No, it's
Should've
okay.
printed it all out.
Mr. Jonathan, how did you determine where the property boundary was here?
Sir, so I looked at the property appraiser's website, and it lists the property line in the property appraiser's website.
Yep.
And that's what I used to determine where the items were. Now, some may be on the other property next to it, maybe, but that's the complaint that we received.
I've got a problem in that I have credible evidence, in my view, on each side as to where the boundary is, and I don't have the means of determining where it is in front of me. I don't have the means to do that. So what I would do is, because I do agree, I do believe, based on the evidence, that it's essentially someone dumping. And I'm not sure, but I have no indication as to where the actual boundary is. So what I would do is I would continue the hearing to the next month and ask for someone to tell me where the boundary is. And then I'd be able to take this evidence and figure out, is it a violation or is it not? I just don't know. Okay?
We can have the GIS department look into that.
It's just, we wouldn't.
I'm looking at a GIS map and the whole pit is in one parcel, which is supposed to be.
It is.
It's not a problem, especially when there's like residential lots and it's easy for us to determine, but here I just can't, so.
And may I ask 90 days, perhaps I could, now that I'm aware of this problem, I can work with this gentleman and, you know, see if there's something that it can be done to alleviate at least what he thinks is, you know,
in case
my
we
part
find
of the
out that it
problem.
is.
Yes.
Okay, is there a public health issue that you're worried about here that needs to be rectified immediately?
The sooner the better. Again, there is trash and debris down in the bottom when he speaks about the water. There's tires down there, things
Probably
like that.
a lot of mosquitoes.
Yes,
but,
sir. Yes, sir.
I'm going to continue at 30 days. Okay?
August 17th, you'll get something in the mail.
Okay, thank you. Well,
All right.
I'll write it down because I may not receive it by August 17th.
All right, thank you.
The next case, Carol A. and Vincent J. Shell. Case number 216-5593. Code Officer J.C. Charlton, page 25 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your names?
Vincent J. Shell.
Carol Shell. Thank you.
Thank you.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 216-5593, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5572 West Novus Circle in Homosassa, Florida. Property owners Carol A. and Vincent J. Shell. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during my initial inspection on June 1st, corrective action inspection on June 21st, and photos of my final inspection on July 19th of 2022. Exhibit B, a copy of the notice of violation, notice of hearing, and a copy of the signed certified mail return receipt.
Sir and ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objections to them being evidence in this hearing.
There have been some changes to these photos. However, I'm not to give you my phone.
Well,
I have showed Officer Charlton
sure.
in the back of the room.
What I would accept, I'll accept your testimony about the changes, and I'll accept your testimony about what's different than the photos. I just need to know if you actually believe the photos are not authentic.
Oh, no, they're authentic.
Okay, that's what I mean.
Yes,
so,
but there has been changes. I spoke with Officer Charlton yesterday morning,
we'll get into that.
and
No, I appreciate that, Mr. Shell. So, without objection, what's been proposed as Exhibits A and B are evidence. And before we proceed, I just want to ask if there's anyone from the public who's going to want to be heard on this case. Let the record reflect that there is no response. Please proceed.
Thank you. I conducted my initial inspection on June 1st of 2022 and observed the refrigerator out in front of the home. I conducted a corrective action inspection on June 21st and observed that the refrigerator was removed, but however, there was debris on the right side of the home that was appeared to be tried to be, shielded by a privacy fence that, wasn't installed all the way. Then on my final inspection, I observed a piece of another privacy fence moved from one area to cover another area that was exposed, and I was able to see other debris on that side of the property as well, on the left side of the property. I've explained to Mr. Shell that, just moving privacy fence here to there is you're, shielding one violation, but then it's open it up to the rest of the junk and debris. So if you just remove all of the debris, that would abate the violation.
And now I'd love to hear from you, Mr. Shell.
that is easier said than done. I have a 39-year-old PTSD son who sleeps during the day, works on motors and stuff at night. Every morning I get up, I have to put stuff back. So
better that you have a 39-year-old PTSD son than a 40-year-old lawyer's son. My parents, I feel bad for them, so it could be worse.
Yes, I'm more than happy to do whatever Officer Charlton requires of me. I spent $1,200 on new fencing.
Right.
But I didn't get enough, so I'll go out and get more to make it compliant.
Well, let's look at this. So, Mr. Charlton, would better fencing abate the violation?
I mean, if I can see the violation, then there's a violation. I can't tell someone to hide violation, junk, and debris.
Right.
But however, I can't tell someone they cannot put up.
Well, no, I want to be clear. So, I mean, if just by putting up a fence that stops you from seeing it from the street doesn't actually get rid of a junkyard violation, correct?
Correct.
Well, we got rid of the junkyard violation.
Yes,
We had a dumpster.
A
Okay.
30-yard dumpster.
We've had
Right now, he's just down to his four-wheelers.
I see.
Foreign junk.
we've had previous cases on the property before. This is the third violation on the property. It was a lot worse in the initial case on the property, but
Was that before me, or?
no, it always abated prior,
I see.
before the
I see. The
before the hearing. But just hiding the violations does not resolve it, you know.
But I was with the understanding that there was one problem on our property, and that because we had a lattice fence up there had to be replaced by a solid fence.
Well, here's the violation here. The violation in this case is a junkyard condition. So I can see in the photos that there's an accumulation of kind of junk and debris in the photos. And you're saying that you already brought a dumpster out and got rid of it? But
Plus, we also have 2 small trailers inside behind the fence that we're loading the metal and stuff on that's supposed to be.
Okay.
Supposed to be going out this week.
So if it's, so it's your testimony that's pretty much already fixed.
To a degree. It's
All
not all fixed. It's a
That's
work
what I
in
need.
progress.
That's what I needed to know. So how much time do you need to actually get to the finish line?
30, 45 days.
Ma'am?
Because it's not just a matter of, you say, okay, it took us forever to get the dumpster, it took forever to get the dumpster picked up. You know, nothing happens in a day. I can get on the phone and start calling, but they don't show up.
Mm-hmm.
So it's like, I'm sorry, I wish I could do it, but I can't.
Well, what's your best guess as to how much time? Is it 30, 45 days?
Well, that would help.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions relative to this violation. We would also ask the special master additionally find that it is respondents' responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
Mr. and Mrs. Shell, I do adopt the county's proposed findings of fact. I'll find that the property is in violation, but I'll grant you 60 days from today to abate the violation. And if the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed.
Okay, could you just clarify?
Yeah.
That if everything is put away and done up, and you can't see nothing from the street,
No.
then I'm not in violation.
No, that's not what I'm
Correct?
saying. No.
I'm supposed to allow the county to come in and look behind my fence or in my garage or whatever?
That's a conversation for you and the county as to how it's verified. What I'm going to say is you can't have junkyard conditions in violation of this code section on your property. And it makes no difference to me whether there's a fence between the street and the junkyard conditions. You can't have the junkyard conditions.
Right,
All right. All right. So if the fine would be recorded and will constitute a lien on your real or personal property, County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owners shall be responsible to pay all costs required by county law, which may also be filed as a lien of record.
Thank you.
All right? Thank you.
Next case on the agenda, Monty Van Ness, case number 216-4874. Code officer on the case, Alan Jonason. Page 31 of your agenda. Carl Jones, expert on the case.
Mr. Jones hasn't been able to escape yet?
Is there 2 minutes?
I've been
We
begging.
can run them together.
Yeah.
Also, case number 216-4873. We'll run them together.
Thank you.
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And your name, please?
Anthony Reeves.
Thank you very much.
Alan Jonason, Citrus County Code Compliance Officer. This is case numbers 216-4874, Buildings and Building Regulations, Chapter 18, Article 1, Section 18A, Permits, obtain after the fact permits for all construction or modifications, the Citrus County Code of Ordinances, and case number 216-4873, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 1005 East Cermak Street, Hernando, Florida. Property owner is Van Ness Monty. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, Photos taken during my initial inspection on 18 May 2022, photos of my compliance inspection on 28 June 2022, and photos of my final inspection conducted on 19 July 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, a photo of the notice of hearing posted on the property, and a screenshot from Hanson reflecting that a permit has been applied for the shipping container.
Sir, you're not the owner, are you?
I'm buying it from him. I've got the contract.
You have a
and
contract?
stuff. Yes.
All right. Well, if you're interested, technically you don't have standing as an owner to contest things, but if you want to view the documents, you can.
Yes.
Okay.
Okay, cool. Yeah, all that's gone. Yeah, that's gone.
I was entertained when I seen that. No, I'm good with it.
Okay.
Absolutely.
Is there anyone from the public who wishes to be heard on this case? All right. Let the record reflect that there's no response.
From where he took his pictures, it was early yesterday morning. It's way different than,
Okay.
I took him 8 o'clock this morning on my telephone. I mean, I can't give you my telephone, but it's,
I'd
believe
rather
I've
not
got-
take your telephone.
Yeah. I believe I got it licked out. I don't think there's an issue no more.
Okay, thank you. Then, without objection, what's been proposed as Exhibits A and B in each case are admitted.
On 18 May 2022, I conducted an initial inspection and observed the property to be in violation. I verified in Hanson that no permits had been issued for the shipping container. On 25 May 2022, a notice of violation was issued for ATF and junkyard conditions, which is a violation of the ordinances listed above. On 28 June 2022, I conducted a compliance inspection and observed that the property remained in violation. As of 19 July 2022, the property remains in violation. Building Director Carl Jones, expert witness.
I've just had the privilege of reviewing a permit that was issued this morning for an 8x45 shipping container on this property. So as of this morning, a permit has been issued for the container.
Okay, and so that would get rid of case number... I assume the county would dismiss case number 216-4874?
Yes, sir.
Yes. All right. Done with that case. Don't need to worry about that. And all that remains is case number 216-4873.
Yes, sir.
Which is the, actually, who's that permit issued to?
Me. Permit is issued to Anthony Reeves.
Okay. And so even though Mr. Reeves isn't the owner yet, he's able to obtain a permit for it?
That's evidenced by this record right here.
Well, I guess you get my. Anyways, it's dismissed. I'm not worried about it. Mr. Reese, so you've indicated, I think, that it's already been substantially cleaned up as of today. Is that right?
As of last night, but I just took pictures this morning.
Okay.
Which, if he can look at them, I don't mind him looking at them if he wants to come out and take more pictures or something. Or
Well,
I don't know how they clear that.
if the county wants to review your photos without showing them to me,
Okay.
and if based on the photos it decides to dismiss the case, then it can.
Okay.
But I can't do that unless the county wants to do that.
I understand.
Yeah.
May I?
No, sir. We can't do that. Right. Sir.
Okay. You're not going to.
I have to do the inspection on my own.
Okay.
Yes, sir.
Okay. So I'm just thinking this through. It's your testimony that it's fully cleaned up as of last night?
I believe it's acceptable for everything you asked me for, yes. I believe so.
Okay.
Now, if I still need to do more, I'll do more, but I like the way it looks myself.
30 days.
Hmm? Well, I
So
mean,
they might ask for 30 days.
I
don't mind the extension just in case I have to do something else.
Okay. Is there anything else you want to tell me, Mr. Reeves? I'm not looking for anything. I
No,
just
I
want to
don't
give.
know what else to
I want.
say. I'm
I just
doing
want to give
every
you a
bit of
chance
it.
to be heard. That's why I'm asking.
I don't disagree with anything that
Okay.
you told me I had to do.
Okay.
The violations is, all that stuff is the same thing that I was going to do to the property anyway.
What I'm going to do is, I guess I want to lay a precedent here, and that is that it happens sometimes that, I mean, code compliance does a great job at getting out there the day before the hearing and giving me a last, as good a, this is the state of the property, but it is conceivable that someone can fix a violation between the time that the photos occur and the time of the hearing.
Yes, that's what happened.
And sometimes at a hearing, it may be that it's unrebutted testimony, that it's actually fixed. And that's hard for me to then say, well, there's no real evidence from the county that it hasn't been fixed. But what I think I'm going to lay as a precedent is that if the evidence provided by the county is credible as of the prior day, that I would still provide a time to verify that it's been corrected to the county's pursuant to the county's case, because as you said, Mr. Reeves, we're not sure. I mean, you're not a code compliance officer, so there may have been something that's been missed, and I do consider the code compliance officers credible witnesses. So I hope that all makes sense.
It makes plenty of sense. I mean,
Okay.
I don't have pictures, and like I said, I don't have a badge on.
Well, you do.
So I
It's
get
just that they're on a phone, and had you printed them out, that'd be a different ballgame.
I
But
don't know how. I was thinking about going to Walgreens and bringing pictures back after we did all that.
that's how my mom does it. So
Okay.
anyway, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day per violation, for the junkyard conditions violation, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
And I think one thing I'm going to add to what I said earlier about the precedent issue is that the reason why I think it has to be that way is if every single time a respondent came in and said, well, no, I fixed it, in the last 24 hours, and then I'm compelled to follow that, everyone will start doing it. And so I don't think we can afford that. All right, so the property is found in violation. I adopt the county's proposed findings of fact. The owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owner, whoever that is. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Thank you.
Thank you.
Thanks, sir.
Yep.
Sir, you're very reasonable.
Thanks. First time for everything.
Next case on the agenda, Wayne and Karen Ashley, case number 2163729. Alan Jonathan, code officer on the case, page 5 of your agenda. Joanna Coutu, expert on the case.
Well, I think you can call a different case if you want. Well, we'd have to swear them in as well, so. Is there anyone where there's no respondent present with?
Yeah, I'll do mine.
I'm sorry, sir and ma'am,
Sorry, I
we don't
forgot
have
what
the
it was.
person who can swear you in at the moment, so I'm gonna ask just to keep it moving that we do another case.
I'll do mine. Next case on the agenda, MWC
You'll be right
Properties
next.
LLC, and Johanna N. Dussel, case number 2161592. Code officer on the case, J.C. Charlton, Joanna Coutu, expert on the case.
What page in the agenda?
This is page 22.
Okay, thanks. I am.
But you can't.
I think I
Can't you
probably
swear?
could.
If you're a notary, you
Yeah.
I mean, judges.
I'll do that.
judges
I'll do
do.
that next time.
Yeah, and
I am a notary, but yeah,
that's what I was thinking, but
I'll do it next time.
that's okay. J.C. Charlton, Citrus County Code Compliance Officer. This is case number 2161592, a violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. The address is 1289 North Groveland Way, Crystal River, Florida. Property owners MWC Properties LLC and Johanna N. Dussel. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos I took during my initial inspection on March 31st. Photos, just inspection on March 31st. Exhibit B, the notice of violation and notice of hearing, and a copy of the signed certified mail return receipt.
All right, is there anyone from the public who wishes to be heard on this case? Or is there anyone from NWC Properties LLC, or is Miss Joanna Dussel here? All right, let the record reflect that there is no response. I'm going to admit exhibits A and B without evidence, or without objection. All right, thank you.
I conducted my initial inspection on March 31st of 2022, and I observed tree clearing on the vacant property zoned medium density residential. While researching the property, I observed that there was no permit to build a home on the property. I've had contact with registered agent for the property, Mr. Bunch. He stated he was not aware of this in violation. I explained it to him. As of today, there's no permit been issued for this property. I'll turn it over to expert on the case, Joanna.
Joanna Coutu, land development, medium density residential should be vacant. There are no primary structure here at all.
Do the amendments to the this code section apply on this case?
Only to the point that they still would need a site development plan.
Okay. What's the county's recommendation?
Due to the nature of this violation, the Citrus County Code Compliance Division respectfully requests a special master assess a fine of $300 per day, along with the administrative costs began after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions relative to this violation. We would also ask that the special master additionally find that it is respondents' responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $300 per day will be imposed. The fine will be recorded and will constitute a lien on the real or personal property of the owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law, which may also be filed as a lien of record.
Next case on the agenda, Wayne and Karen Ashley, case number 2163729, Code Officer Alan Jonason, page 5 of your agenda. Expert on the case, Joanna Coutu.
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
Thank
Please
you.
state your names.
Karen Ashley.
Thank you. Thank you.
Thanks for your patience.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 216-3729, violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address of the violation is 6594 North Anchor Point, Hernando, Florida. Property owners are Ashley Wayne and Ashley Karen. I have good service via signed certified mail return receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on 3 May 2022, and aerial photos taken from the property appraiser's website. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Ma'am and sir, I'd like to ask you to review those and let me know if you have any objection to them being evidence in this hearing. Take your time.
That's the date of these photos. Yes, sir. That's where the satellite went over and took the photo. It shows the tree canopy. That was before we owned the property. Yes, sir. Yeah, that was on the 20th. That was in 2021.
Is anyone here from the public who wishes to be heard on this case? And I don't see a response.
We have no objection.
Okay, thank you. Without objection, what's been proposed as exhibits A and B as evidence?
I conducted my initial inspection on 3 May 2022 and observed that the property had numerous trees removed and there was a fresh burn pile in the center of the property. While researching the property, I observed that there were no permits applied for or issued, and the aerial photos from the property appraiser's summary depicts a large amount of tree cover on the property before the trees were removed. I have not had contact with the property owner, and as of my final inspection on 19 July 2022, there has been no permits applied for or issued. Joanna Coutu is here from Land Development, expert witness.
Yeah, Joanna Coutu, Land Development, Coastal Lakes Residential. It is a vacant site. There are no primary structures and no applications.
Okay. Have trees been removed?
Yes.
Okay. So what's going on with the property?
I would like to say that when we came here, we live in Maine. We're from Maine, and when we bought the property, we bought it sight unseen. The gentleman that we bought it from said that he had cut trees and had it surveyed and done some work to it. So when we bought it, and when we come to look at the property, it says, oh, you know, it was a nice piece of property, we liked it. The biggest thing that we saw was there was a lot of brush, and there was a lot of, like, we found plastic bread bags and some trash on it, and we cleaned it all up and cleaned up the brush and stuff. There were a couple of trees that we did cut, but one of them was rotted. There was another one that wasn't. We did cut that one. And then there was another one, I think we trimmed off one of the branch because it was rotted and falling off.
Can I speak to that?
Yes, go ahead.
I have some photos before and after we did the cutting that clearly shows what we cut.
Okay. I mean, you're basically conceding that, hey, there were some trees cut.
We cut 3 trees and we cut a limb off of a 4th tree. 4 trees in total.
Which limb from the tree? I'm just kidding. It's okay.
I have photos to show what we cut. The previous owner had cut trees before we bought the property.
Yeah.
And there was actually a pile of
And we have
wood over in the woods and we did burn that pile because it was
3/4 of what we cleared. We
from
cleared with
previous.
using a lawnmower.
I have a question for the county. If they hadn't cut any of the trees down and it had been a previous owner, you know, when a judgment comes out of the code compliance hearing, it's against the owner, you know, and it becomes a lien possibly on, well, it certainly becomes a lien on the property, but it could become a judgment against the people who are the owners. If the evidence shows and everyone agrees that it's the prior owners who actually created the violation, are they not at issue? Should they also be parties to this, or is it proper for a judgment just to be against the people who didn't do it and took ownership of the property without knowledge that it happened? And they did have knowledge, but I'm just saying if they didn't.
I can't determine that, sir.
Mm-hmm.
I have no way to do that.
Okay.
We go by what's.
But I'm saying if you agreed, would they be responsible, and would I be able to issue a judgment against them?
The
or
previous owner or the
either
current owner?
Yeah, I mean,
the current owner, yes.
I would. Okay.
When was the violation reported?
3 May 2022.
And I don't think these are the facts here, Ms. Antrim. It sounds like they're agreeing that they cut some trees. But I'm curious about the situation where. Does it make sense what I'm asking?
Yes.
Okay.
It does.
Well, it may not be ripe for consideration.
And I think the code says the violator.
Really? Interesting. All right. So good for future knowledge. What's the county's?
Says the same thing. Violator.
Wow. Okay. No, that's really important. All right. Thank you. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $200 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation.
Can
we
take a break?
Yeah, I'm sorry. Can we take a 5-minute?
To discuss this.
Okay.
Sure.
We'll do a recess 5 minutes.
Okay.
Thanks. The time is 11:53.
This is unusual.
It is. Yes, ma'am. Me too. Absolutely.
It is unusual that they've come across something that they want to discuss before the judgment is handed down in court.
It wasn't our intention to go against code compliance.
Let them do their thing. See what they said.
You still have. Yeah, no, yeah. Remember off the top of my head. Florida was in, yep. Yep.
That wasn't issued this morning, was it?
Funny, you know, it shows up, you know, they have this, they're like 25 inspections.
I know.
A whole afternoon work.
Hey, join the club. Yeah. Go. I'm not trying to keep you here. It's just.
No. Oh, I fully blame that.
Yeah.
Trust me, I have plenty of inspections to do
Yeah.
too.
I may have a smidge of papers.
Yeah, because why would you be in Florida during the summer? If you don't have to be. Right. Yeah, yeah, don't remind me.
I'll take 88.
I was gonna say, if you think. Are you ready, Ms. Antrim?
Yes.
All right. Time is 11:56. We're back from recess early. Is the county going to proceed with this case?
Yes.
All right. My question next is there an exception in LDC 4002 that applies? In other words, subsection B?
Not understanding what you're asking.
Well, what's the specific violation that I'm looking at in the code?
Site development without a development order or permit.
Okay. And is that in sub A or sub C? Sub B?
4002, I'm not for sure.
I'm in 4002.
Okay.
It's just there's a lot here, so I'm wondering which.
It's A, no development allowed.
Okay.
Which would be the
Cutting of the trees.
cutting of the trees and preparing.
Okay. No development allowed by this code shall be established, changed, or altered until there is first on file a site development plan. A site development plan shall be required for any multifamily residential development and non-residential development. The following are exempt from this requirement: agriculture, single-family dwellings on either lawfully platted or recorded lots, or lots in recognized unrecorded subdivisions, duplex residential structures, or lots in recognized unrecorded subdivisions, accessory structures, and other uses that do not require extensive review by county staff and can be approved through the building permit process.
You're reading the old ordinance, but
Well, that's what
Well,
that's
this
why
violation was under the old.
That's
one.
why I
Right,
asked
just-
earlier if the amendment applied, at least to the. I've reviewed the amendment. I think
it's
it would.
similar.
I think the amendment would make this very clear. What are you doing with the property?
We originally planned to build a home there, and when I first spoke with Mr. Jonathan, I apologize for my raspy voice.
No, I can
have
understand you.
asthma.
Is it painful to speak? Because I mean.
No,
okay,
no,
all right.
it's just, I'm old and it's raspy.
Okay.
That's all. Yeah. I first received a notification on the 20th of May for the code violation, and I spoke with Mr. Jonathan on the 24th of May, and he said to keep communicating with him about the permitting status. We explained what we were trying to do with the property, and my wife was on the phone at minimum of 3 times a week, leaving voicemails on his. I realized, I see today why he's so busy.
Yeah.
But we were unable to contact him at a week at a time.
Sure.
When I spoke with him on the 24th, we hired a gal from Prestige Homes named Angela Delker, and she was going to prepare a site development plan for the property. I tried to get a hold of Mr. Jonathan on Friday, the 3rd of June. I finally was able to leave a voicemail, and I was informed he was not in the office on that day. And Angela Delker informed us that code enforcement had rejected her site plan. And they were not gonna accept a site development plan, and we had to do a full-fledged building permit on the property. We were not prepared to do that on such short notice. There was no way we could comply with that by the 14th of June. We contacted Prestige Homes again, a second time, and they told us it was a minimum of 6 to 8 weeks to get the permitting process completed that he was requesting, I guess. So, in the meantime, they wanted $180,000 up front.
Who's they?
Prestige Homes.
Okay.
We didn't
And we were not prepared to do that on such short notice. So, to make a long story short, my wife and I got very distraught about the property. So we decided to sell the property, which we did. We actually sold the property.
Sold this property?
On the 10th of June, we sold the property to the neighbors.
Okay.
But we still feel that, I mean, we don't want to pass this on to anybody else. I mean, this
He
is-
informed us that the sale didn't negate the violations. So that's why we're here
I think
today.
that's interesting. So Ms. Antrim actually helped clarify that, because I guess the code, it's against violators, which it should be. Although you're not the sole violator in this case. It sounds like your predecessor also was a violator.
We agreed that the new buyers, we would take care of this problem.
Okay.
We made good on that. That's why we're here today. We were so upset with the process, we decided
We were
weren't gonna
just
build the home.
devastated by the whole thing, and I just told my husband, I said, we can't do this because,
Well,
you know, we're from Maine and, you know, trying to do it through the states.
Is there a, do you know if this is a platted lot?
Yes, it is.
It is platted?
I have the survey here, if you'd like to see it, yes. Yes, it is.
It's residential.
While you're doing that, just Prestige is usually mobiles. Are you looking at a modular
We
home?
were informed that
Can't-
mobile homes were not acceptable.
Right. You have to do them. Yeah, you can't
After
do a
the
mobile. I just didn't want to
fact,
waste your
yeah.
time with that. Okay, you can't do a
Even
mobile.
though there's a
Yeah.
mobile home next to us.
It's not zoned for mobiles.
Right, we were informed of that, yes. Yes.
And here's what I'm agonizing about. It's subsection B. So subsection A requires a site development plan. Subsection B says a site development plan is required unless it's a single-family dwelling on either lawfully platted or recorded lots, or other uses that do not require extensive review by county staff and can be approved through the building permit process.
There's no single-family dwelling there.
Although that's what they intended on doing, and it is lawfully platted, and even if it wasn't, this is not something that would require extensive review by county staff to approve.
Disagree. It does require a review by county staff. Extensive review, not extensive review, was supposed to be little things like well houses and basketball courts and that kind of thing. Tree removal would.
Tree
Fortunately-
removal?
Tree removal, yeah. A tree removal permit as part of a single family, yeah, that requires a review.
But how much review does it take that would be different than...
Well, they can't get
for-
the tree removal
than-
by
I'm
itself.
sorry, hold on. How is it much more extensive than the review for a basketball court?
Well, it would be a single family home with tree removal. I'm sorry, I misspoke. Not tree removal by itself. It's single family
Okay.
home with including the tree
Okay.
removal. When it talks about not through the permit process, that's that exemption that they're trying to do, is if you're doing something so mild that we really don't have to review it.
But I'm still struggling, because if that's true, then why would single-family dwelling on a lawfully platted or recorded lot be exempt, but a single-family dwelling on a lawfully platted lot or recorded with a basketball court, with tree removal, be any different?
I'm just saying that the way it's worded, that the not extensive review would not exempt a single family dwelling with the tree removal. Fortunately, we've cleaned this up, but I see your point.
Oh, okay, all right. It is cleaned up, and if it's the amended code section, there's no issue whatsoever. I was hoping you'd be walking back out of that room with a different response. I don't understand how the exemption doesn't apply. But I welcome you to tell me how I'm wrong, or how it does apply, or I mean, I'm sorry, how the exemption doesn't apply here.
Because there's not a single-family dwelling in this case. It would be exempt if it was a single-family dwelling on lawfully platted or recorded or unrecorded lots, but it's not.
In other words, if they had put the single-family dwelling there without a site plan.
We might be able to apply this section the way it's worded, yes.
Okay. But because it's tree removal.
It's not a single-family dwelling, it's not agriculture, it's not the duplex,
But isn't
et
that
cetera.
something that wouldn't require extensive review by county staff?
I guess
tree removal?
It requires a lot of review. We have to look at the sizes and the size of the lots, and not so simple.
And I think I see your point. It's just where I get hung up is it lists all these things, agriculture, single-family dwelling, duplex residential structure, and then it says, and other uses that do not require extensive review, which implies that a duplex residential structure, a single-family dwelling on a lawfully platted or recorded lot, the agriculture.
Does sound like that. Can I throw another wrench into it?
Throw the wrench.
If you look at section 162.07.
162.07.
Oh, I'm sorry, 06.
06. Are you gonna?
Subsection 5 addresses transfers during transfers of ownership.
Right.
From the time of the initial.
Yeah.
It says pleading.
Right.
At the very end of that section, it says, if the property is transferred before the hearing, the proceeding shall not be dismissed, but the new owner shall be provided a reasonable period of time to correct the violation before the hearing is held.
Okay, so I hate to do this to you, but I think what the
Now,
assistant.
we don't see a deed yet, but that's probably because it hasn't been
you know,
picked up by the property appraiser.
you can't always trust people from Maine, but in this
I'm
case,
not saying
in
you
this
can't
case, I'm
trust people.
joking. I have no evidence to suggest that what they've represented isn't accurate, and because of that, and
Copy of the deed transfer.
that's okay. And my concern with due process that's been announced is I think I need to continue the hearing, okay? A sufficient amount of time to put the new owner on notice. Would you mind telling us who the new owner is?
New owners are here.
Oh, they are. Okay. Well, that's another wrench.
But I don't know that they've been given.
But I can ask them.
Oh, okay.
Sir, are you the new owner?
Yes, sir.
Would you mind coming up and swearing an oath and testifying? Right when you had the easiest out.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your name, please?
Douglas Everett?
Thank you, sir.
And you're a neighbor. You were a neighbor before purchasing the property?
Yes.
Okay.
Relatively close.
I see.
Same street?
Just up and around the corner on North
Oh,
Shore
okay.
Road.
When did you find out about this case?
Well, we're related by marriage, so we knew about it. And when they decided that they'd had enough with trying to deal with the county and everything, they wanted to sell. And before it went to a realtor or anything, we offered to buy.
Initially, they were interested in the property. That's how we found out about it.
I got you.
They were thinking about buying it.
Mr. Jonathan, what would it take to abate the violation? If I found one.
You have to put a house on it, sir. Residence.
Are you
And
planning on?
we have no designs of building on the property in the foreseeable future, maybe 4 or 5 years from now, yes, but not now.
I'm sorry, I want to apologize to everybody because we did this to ourselves.
No, it's not your fault. It's mine. I'm not making this easy on either side. Just give me one moment to agonize about this some more.
Can we have another break?
Yes. The time is 12:10, 5-minute recess. Oh.
It's not sore.
Oh, okay. I don't know. Okay.
We do. Due to the nature of the violation and the dialogue that we've all had with the property owners, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 for the violation.
And so that would be under the theory. That would be under the theory that it is a irreparable harm. Correct?
Yes, sir.
Okay. Under what code section can I do that?
5710.
5710?
5710.
Wow.
Good call.
I believe that's correct.
Yeah,
I just want to check.
Yeah, we rewrote it a little bit.
And on what basis can I do that when they haven't been put on notice that this code section is at issue prior to the hearing?
The alternative is they would have to put a residence on the property, sir.
And then there would be the daily fine until they could, and so we.
If I find there's a violation.
If there is a violation, yes.
many of the trees, this is for the Ashleys, you said you removed 3 trees? How many of them were dead?
One,
Okay.
I have photos to show the trees that we cut.
And how big were the other 2?
There were 2 trees that were 4 inches in diameter. And there were 2 trees there was one tree that was 12 inches diameter. And one limb that was approximately 12 inches in diameter. I have the photos, before and after.
Ms. Antrim, so for the purposes of a hearing like this, normally due process is the most important thing that we can give property owners, and there's no real dispute that they didn't know this code section was going to be coming up against them today. It's not on the notice of violation. It hasn't been discussed with them. This is, however, both in criminal proceedings and in other proceedings, it is possible to amend a charge, so to speak. And I don't find it inequitable, given that I do think there is a violation here for the tree removal. A very, very small violation, but one nonetheless. Do you believe that I have authority to actually find in favor of the county on this code section, even though it's not in the notice of violation?
Only if they would waive their right to notice, but another alternative is we can dismiss this case and we can actually proceed under the citation provisions, where a citation can be issued to them, and then there's the standard tree fine. And what's the tree fine?
For the fine citation?
Yeah.
I believe in our fine schedule it's $300.
Oh, so that would be.
And you're recommending 100 today?
Yes, sir.
You sure it's 300 if it's citation?
Yes, but then it can be based on, the severity of it. So if there's,
Let me explain this to you guys in case it's not clear.
$300 for tree removal.
I do not think there's a violation under 4002, the one that you've been charged with today. I do think it fits under the exemptions. The code has recently been amended to solve that problem. If we were going under the amended code, I would have to find that there's a violation. However, what the county is suggesting is that if I don't do what they've recommended here, you're going to end up paying more later. So I feel that it's probably the most equitable result that I accept the amended charge, so to speak, under the tree removal code section and assess a $100 fine. If you insist, I will not let them do that, and you'll probably get a citation for $300. Does that make sense?
I guess.
All right. I'll find that the property is in violation, that the violators are the Ashleys, and that a $100 one-time fee be charged for a violation of section 5710 in consideration that there is there is an exemption under 5715 for one of the trees, but not for the other 2. And that's it.
Thank you.
All right, thank you.
Thank you.
Good luck.
Thank you.
Okay, next case on the agenda, Glenn H. Danaher, case number 216-4073. Code Officer Alan Jonason. Expert on the case is Carl Jones, page 16 of your agenda.
Good afternoon.
Good afternoon.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 216-4073, Chapter 18, Article 1, Section 18-8 Alpha, obtain after the fact permits for all construction or modifications of the Citrus County Code of Ordinances. The address of the violation is 9600 West Pimpernel Lane, Crystal River, Florida. Property owner is Danaher Glenn H. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 10 May 2022, and a printout from Hanson indicating the permit was never finalized. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no one. Thank you. Without objection, what's been proposed as exhibits A and B are evidence.
On 10 May 2022, I conducted an initial inspection as well as verified in Hanson that no permits had been issued, which is a violation of the ordinance listed above. On 11 May 2022, a notice of violation was issued for ATF, which is a violation of the ordinance listed above. As of 19 July 2022, the property remains in violation. Carl Jones, Building Department expert on the case.
Do you have any questions for me in particular?
Is there anything you'd like to contribute or add?
I have nothing to add.
Okay. So this is a roof issue?
It's an after the fact. Well,
For what?
I guess it's a roof.
Okay.
A roof that was put on a.
What I'm looking at on
barn
page
back there.
2 of Exhibit A is, you call it Hanson, I think?
Yes, sir.
And it appears to show that there's an application for a roof
An application was submitted.
permit,
Yes, sir.
but no permit's been issued.
Yes, sir.
Okay. So they already did the roofing?
It's been done. Yes, sir.
It's been done. All right.
From my understanding, yeah.
And how do you know that?
Based on the picture, it shows the roof back there on the, I guess, garage or whatever that is. The structure back there.
Can you?
Yeah, absolutely.
I'm not trying to make you
No worries.
hustle, but I don't understand. So it's the back.
Yes, sir. Yes, sir.
Have you had any contact with the owner?
I have not.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed. The fine will be recorded and will constitute a lien on the real or personal property of the owner. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the property owner shall be responsible to pay all costs required by county law, which may also be filed as lien of record.
Thank you.
Thank you.
Thank you.
Good luck.
Next case on the agenda, Sean Carpenter, case number 216-4722. Alan Jonas is code officer on the case, page 11 of the agenda.
Sorry about that.
Can you please raise your right hand, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Your name for the record, please?
Sean Carpenter.
Thank you.
Good morning, or good afternoon.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 216-4722, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 3449 East Bear Lane, Hernando, Florida. Property owner is Carpenter Sean. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 17 May 2022, photos from a compliance inspection on 3 June 2022, and photos of my final inspection conducted on 19 July 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail receipt.
Mr. Carpenter, I'd like to ask you to look at these and let me know if you have any objection to them being evidence in this hearing.
No objection.
Thank you, sir. Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response. Thank you.
On 17 May 2022, I conducted an initial inspection and observed the property to be in violation. On 17 May 2022, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On 3 June 2022, I conducted a compliance inspection and observed that the property remained in violation. I've had contact with the property owner, and as of my final inspection on 19 July 2022, the property remains in violation.
Exhibits A and B are introduced as evidence, but I would note, I don't know if you factored this in, Mr. Jonason, on page 3 of 11, it appears that there's 3 dachshunds, and those are not junkyard dogs.
No, sir.
So I don't
No,
believe
sir.
that this can
There's
be...
more than that now. I think he's got
you
like
might,
6 of
I
them.
think you might be in trouble. Mr. Carpenter, what's going on?
Let's see. I had I got like 18 houses I try to take care of for my best friend, which is deceased. I help his widow. We go into these buildings and people leave stuff behind. I mean, I don't know about you, but I mean, the gas prices now are like off the chain. So I decided I was going to try and make some extra money, take the stuff and put it in piles at the house for like aluminum, metal, steel. You know, then you get your appliances, you know, which is stainless steel and, you know, just 5 or 6 different things, you know. So I'd put them in piles at the house. We'd get like probably two houses at probably a month here that we would, you know, go and have to clean out and just stuff like that. But anyway, I was just trying to make a little bit of extra money. I was using my property, you know. It was never really the same thing for the last 60 days. I mean, it's an accumulation of like something this month, or, you know, because we would take the stuff in like every week. I mean, we would pile it just for like a week, and then we'd take that in. And then next week we'd have a couple more houses to do, so we'd pile it and then take it in, you know, to make that extra money. I mean, I'm disabled, man. I only make $780 a month, and then I try to help my best friend's wife, you know, and just, I don't know about y'all, but I mean, I was making $3,000 before I got hurt on a boat, and now I'm down to $780. I mean, it's just off the chain. I try to do the best I can, and I'm not the best at par, as far as health-wise. But I try to make my bills and make ends meet. He came by yesterday, and every time that the man has come by, if I was there, I would talk to the man. And he's, would always say, well, you're making an effort. You're making an effort. Yesterday, as far as those pictures are concerned, there's nowhere near that stuff there anymore. The only thing that's in my yard right now, I've got some mulch. It goes into my flower beds. I've got like probably 15 bags of this mulch, which was given to me. It goes in my flower beds that I haven't had a chance to do yet. I also have like 6 cans of garbage. It's not complete garbage. I mean, they're cans, but if I was to throw my cans, I would usually put them out to the road on the right side of my property. And when I would do that, all the damn neighbors would come by and use my garbage cans. All right, and I'd have to take it to the dump. All right, so I put them inside my fence now.
Right.
It's where I'm the only one using them. But I mean, I've got 6 of them, and I mean, I guess 6 cans kind of look weird, sitting by your front gate, whatever. But
well, that's not a
measures,
problem.
It's measures I take, to try not to have to take everybody else's garbage and pay for it.
Well, I guess, so the issue here is, it sounds like you've made a lot of improvement. The only real issue is how much time do you need to get it to a point where all the debris and the junk is removed?
Well, I mean, I got pictures. He just got pictures yesterday.
Right.
The only things in the yard is the mulch and my garbage cans. That's the only thing in the front yard.
It does show some improvement from yesterday, and I see what you're saying. There's the garbage bags.
Yeah. Now those garbage bags are not really garbage bags. Okay. I don't have just 3 dachshunds. I've got 8.
Nice.
All right. So and they're not just dachshunds. They're double dapple dachshunds. They're one of the rarest dogs in the world. But the babies, before, you got to train dogs, whatever. Well, they sleep with me, sleep with the wife, whatever. And the babies, they defecate, whatever, just being babies. So the covers would be washed out on the fence and then dried and thrown in a bag. Well, I went to go down to do them all in the Hernando laundromat because you can't really do covers in a small wash machine, and that's the only thing on the sidewalk. That's not really junk. It's just.
Well, Mr. Carpenter, I guess it's just how much time do you need to get rid of all the debris and junk?
I just need to go to the laundromat, and then really all the junk and debris. There's not really junk and debris. I got a small little lean-to thing behind my house where all my stuff that I keep that I need for my home, and my extra stuff to. All right, like I got a brand new sinks. I got a couple of brand new sinks. I got 4 of them. I've got a brand new bathtub, which is an 18-inch deep. It's an 18 by 24. Brand new shower. I mean, I don't know where else to store them. I don't have.
Okay, well, let me actually go back to Mr. Jonathan. So I'm looking at the photos from yesterday. Are the garbage bags part of the junkyard conditions?
Yes, sir.
Okay. And I see plastic crates, a stool, a plastic table against the fence, some other things. Are those part of the junkyard conditions?
Sir.
Okay.
Yes, sir.
I'm looking at another photo from yesterday where it's hard to describe all this stuff. It looks like some a disassembled bed frame. It looks like some chairs, some things like that. Are those part of the junkyard conditions?
Sir.
I see some tires. Are those part of the junkyard conditions?
Yes, sir.
So, Mr. Carpenter, what I'm getting at is how much time do you need to get rid of all that stuff, including the other stuff that is junk and debris that you may not consider junk and debris, but the county does consider junk and debris?
I mean, I don't know. I mean, I just, like last night, I raked up everything, I don't know.
Is 2 months enough?
That's way too much time. I mean, my yard is nowhere near what it used to be. I mean,
I agree.
You know, I've been, you know, as far as just trying to make a little ends meet. You know, I'm not really. There's so many properties around my house that's so much worse condition that I just don't understand why I'm being picked on.
Someone filed a complaint or made a complaint. That's why. And so
Yeah, it's
sometimes people don't complain about others, you know, and they can only operate based on the complaints they get.
It's my neighbor. We were having a feud over things, but I know who did it. And
but if 2 months is too much time, is 1 month enough time?
I mean, I'm pretty much. I mean, I'm pretty much there. Besides the garbage bags that I've got my bed linen in them, you know, on the thing, and the garbage cans outside. Everything's gone.
Do you feel that 1 month is enough time?
Yes, I mean, I'd like him to come back and get this case over with. I don't want to sit out here and linger for 60, 90 days.
Okay. And I'm sure he agrees.
Just want it over with.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I have something to say about that. When he was just reading that off, he was saying that I was, from what I understood, he was saying that I was a constant disarray, whatever, was kind of blowing him off, wasn't doing nothing. That's really not the case if you look at them pictures, because every time he came back, there was something different. I mean, I was trying to comply, and it's not like I'm a nuisance or repeat offender here. It's just, you know, I was just trying to make a little extra money, and things got out of hand, and it's pretty much
look how
taken
big
care of.
These are all the codes you have to follow. So it's.
I understand. Yeah.
It's difficult sometimes, but we all have to do it.
Yes,
so
sir.
What I'm going to do is I am going to find that the property's in violation. I'll note that I think that's why he's recommending $50 a day instead of something higher. That's the lowest that we go, and it's probably because you cooperated and tried. So I'm going to grant you 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and would constitute a lien on your property if it gets to that point. And the county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the owner shall be responsible to pay all costs required by county law, which may also be filed as a lien of record.
All right, yes, sir. And I have another thing to add here. They had came back, or he has came back. I guess we have a, excuse me. My wife has got a shed.
That's a different case.
Okay, there's a separate case that I can't hear right now. Hopefully y'all fix it so it doesn't come in front of me.
Yeah, I was just letting the man know that we're getting it moved over to the property beside it.
Thank you,
sir.
Next, 2 cases on the agenda, James N. and Elizabeth R. Pike, case numbers 2161599 and 2161871. The officer is J.C. Charlton, pages 23 and 24 of your agenda. I was going to say good morning, but it's afternoon. Good afternoon, sir. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir. And your name, please?
James N. Pike.
Thank you.
Good afternoon. You've been patient.
Yep.
Thank you. Good afternoon. J.C. Charlton, Citrus County Code Compliance Officer. These are case numbers 2161599 and 2161871. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A, and a violation of unlicensed and inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 9841 North Snowball Point, Crystal River, Florida. Property owners James N. and Elizabeth R. Pike. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Photos taken during initial inspection on March 31st. Corrective action inspections on May 2nd and follow-up inspection on May 22nd, and my final inspection on June 19th of 2022. July 19th of 2022. Thank you. Exhibit B, the notice of violation, notice of hearing, a copy of the continuance letter that rescheduled the case for today's hearing, a copy of the signed certified mail return receipt for both cases.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
Please. And what is this one? Same pictures?
The unlicensed vehicles, it's same, but I mean different areas of the property that show vehicles.
Well, that's a licensed vehicle over here, my Bravado, and that's tagged. That's, that was picking up garbage and putting in that. Okay. Yeah, this is, I ain't got nothing to say about it. It's on my place.
Any objections, sir?
Oh, no, sir.
Okay. Without objection, what's been proposed as Exhibits A and B will be evidence. Is there anyone from the public who wishes to be heard on this case?
Nope.
I still ask just sometimes all that you get is an audio record, and it helps to make everything clear. Although now we have the video, and you'll be on YouTube very soon. So.
Yeah, I wouldn't doubt it. As I was talking earlier about something about kids coming to mow your yard. How can they mow the yard when they can't put the phone down?
Yeah, you're right. That's dangerous, isn't it? I'm no better, to be honest, so that's the way it is.
I hardly ever use my phone.
All right.
I conducted my initial inspection on March 31st of 2022. I observed violations of accumulation of junk and debris and unlicensed and inoperable vehicles on the property. There was scattered trash, tires, scrap wood, metal debris, torn tarps on the property. Also observed inoperable vehicles, unlicensed vehicles. I've had contact with Mr. Pike. He requested more time and a continuance was granted. He has made significant amount of progress on the property as far as the junk and debris. He has stated he's working on removing the unlicensed and inoperable vehicles also.
Okay. I mean, it looks like there's substantial progress. What remains to be done on the junkyard?
Mainly the cars.
Is that true?
Well, there's some debris. If you can see, I believe on the back side of the property, the back right of the property, there's a pile.
Pipes. How about them?
Power piles.
I see a couple piles. Okay.
Yes.
Along the fence line, is that what you're talking about there?
Yeah, and then there's, some stuff along the fence line too. It was some tires and stuff that was, but he's made a lot of progress.
And then on the, let's see, inoperable vehicle, how many vehicles are subject to this case?
When I was able to see, if there's an RV that's there that's unlicensed, and there's an inoperable green truck without that's appears on a jack without a tire. It also has no tag. There is a red SUV in the back of the property also, and there are some vehicles that I was able to be seen during the initial inspection that could be seen through the screen material that was set up.
Ms. Antrim, did you review the photos?
Yes.
Okay. Mr. Pike, is there anything you'd like to say?
Well, it's just, I'm going through a terrible divorce, and we're fighting over the house, and it's coming up due 3 weeks, I think, my court date.
Okay.
The final date. That's why we couldn't settle on nothing, because we're fighting over this house, which I definitely want to keep. I've been living in like a recluse since my wife left me because I didn't want this divorce in the first place. My daughter's boyfriend at the time, he's in jail, probably going to prison because he tried to kill her in the middle of the road a couple months back. My mail hadn't been coming to me. I think he's been stealing. I think he was living in the woods and stealing the mail because I never received his first notice, so I didn't even get started till the second time, till I seen he put a sign in the yard. And then right after he put the sign in the yard, and I called him when he was going to get this set up to start cleaning up, I go to the doctor. I hadn't been to the doctor all year because I'm a diabetic and I'm disabled. Get my blood work done and stuff, and I come out from the doctor 2 days later. My wife also works there. She's a practitioner there, and we didn't see each other, but she comes down with COVID. My doctor comes down with COVID. My daughter's the office manager there, comes down with COVID. I end up sick. I didn't even go to the doctor to even see if I had COVID. If I got COVID, I'll just stay home and die. That's kind of the way I've been feeling with life. I was missing my wife so bad, but anyway, I got feeling better, and I have no friends. I've been married 32 years. My wife was my best friend, and all I had was family. And I was gone a lot. I was a auto hauler, and I was gone a lot. So you don't make friends on the road. I mean, you acquaintances, but you don't have friends. So I'm going through this divorce, and I asked for people to. When I found out about it, I said,
"You asked for the continuance."
Well, I asked for the continuance, but I asked for my kids to come help me.
Oh, right.
But we're going through this divorce, so they don't want to help me because they don't want to. Mama says, why am I helping you and not helping her, or something like that? So I feel like I got the plague with my kids. So all I've got is my 83-year-old dad with Alzheimer's, and it's just me and him is doing this. We're slow, and I'm crippled, and he's slow, and he forgets what we're doing sometimes, but he gets back and helps me. We started getting the place cleaned up, getting the yard mowed, and the fence worked on. We're having problems with this motorhome because it's actually not mine. It was originally mine, or my dad's. It was really my dad's, and then he gave it away. The boy he gave it to ended up going to jail. The boy that went to jail gave it to another friend of his. So now it's been given away twice. I don't care. If I can find a title for it, I'll get somebody to come get it, maybe.
Well, just the issue is, it's probably, I guess it's a part of the violation here on the inoperable vehicles. And the reason why I asked is, obviously you have a lot going on, but how much more time do you think you need to fix both of these issues?
If I can get that motorhome out of there, the other ones will come out.
Okay.
It's right in front of the gate. It's the problem, and trying to get it out to get the other vehicles out, because I don't really need the vehicles no more. But when the kids lived there and stuff, we had 4-wheel drives and mudslinging, and they were parts vehicles for our mud trucks. but I'm too broke down to do that stuff. And my kids have got their own lives now. You know, I've got grandbabies now. I don't have, the kids ain't around no more. But I have no problems getting rid of them.
Okay, I mean, but that's part of it. The other part is finishing the job you've already started,
Right.
which is
It's just me
you're
and my
almost
dad are
there.
slow, and it's just me and my dad. And like I said,
Yeah, don't make him do too much.
well, he outworks me actually. He gets around better than me. He just kind of forgets where he's going.
So normally what I do is I say 30 days, 60 days. You know, I need
Could I
to
get 90 days?
If you want 90 days,
That would give me time to get through this divorce deal.
Okay.
And maybe
All right,
she
you
wins the
think
house
90
and I
days.
just walk away.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask the special master additionally find that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection. For both cases, $50.
Okay,
I'm
okay.
sorry.
All right, so in each case, I will find that the property is in violation, and I'll adopt the county's proposed findings of fact. In each case, I'll grant 90 days from today to abate the violation. And if the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This will be true for each case. The fine will be recorded and would constitute a lien on the real or personal property of the Pikes. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the Pikes would be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Is there anything else? All right.
Say, I know, when I come out, like I said, I've been living like a recluse. All that garbage and all that trash in that front yard was not even mine. That was my daughter's crackhead boyfriend.
Right.
And I just didn't care at the time, you know, because my life was in turmoil. It's still in turmoil, but when I seen it, I was like, I called them right away when I seen that sign. I says, I will get something done. I just remember it's me and my dad, and I'm old and slow, and he's old and slow, but we'll get it taken care of.
Well, as Captain Pike says in Star Trek Strange New
Yeah.
Worlds, warp speed.
Yes.
Thanks.
So my warp speed is about like a turtle.
That's impulse power, so yeah.
Can I call you when I have you come out and check me sometime? Okay. Y'all have a great afternoon.
You too.
Next case is on the agenda. Christopher Ball, case numbers 2165624 and 2166664. Code Officer Amy Becker, pages 6 and 7 of your agenda.
I've looked through the agenda and think I have a general understanding of how many cases are left. Does anyone need a break before we do the final stretch? Okay, all right, thanks.
Amy Becker, Co-Compliance Division. Case number 2165624, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61, and case number 2165137, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20.
216-537 is not a case number I have 216-5624 and 216-6. There's a lot of sixes there. That's dangerous. I don't know, but
it's.
Oh, I'm sorry. My mistake. I had it. I was
Okay.
reading the other one.
Okay.
I brought them all up.
Sure.
Sorry about that. Thank you for the correction.
Yeah.
Okay, so 2166664. 2166664.
Yep.
Yeah.
Yes.
Okay. Accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address for both cases is 9335 North Elliott Way, Citrus Springs, Florida. The property owner for both cases is Christopher Ball. I have good service via posting of the property as well as the Lecanto Government Building, and I would like to authenticate the following documents and request that they be admitted into evidence. and it'll be the same exhibits, it'll be the same dates for each case. Exhibit A, photos taken during my initial inspection on June 2nd, photos taken on June 16th at my corrective action inspection, photos taken on July 1st showing the posting of the property, and photos taken on my final inspection on July 19th, 2022.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response. And what's been proposed as Exhibits A and B in each case will be admitted without objection. Thank you.
You have to mention Exhibit B.
I didn't mention Exhibit B. I'm off today, I apologize. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit for both cases.
Yep, they're admitted.
So, on June 2nd, I conducted my initial inspection for excessive growth and accumulation and observed grass in excess of 18 inches at the property. I also observed junkyard conditions, which included scrap metal, concrete, and other debris, which is a clear violation of Article 3, Section 20-31A.
What's the county's recommendation?
On case 216-5624 and case 216-66664, the Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day per case, along with administrative costs, to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation each case. I'll grant 30 days from today to abate the violation in each case. If the property is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This goes for each case. This fine will be recorded and will constitute a lien on the real or personal property of the owners. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law, which may also be incorporated to the lien.
Thank you.
Next case on the agenda, Edward and Don Thomas, case number 216-5137, Code Officer Amy Becker, page 30 of your agenda.
Amy Becker, Citrus County Code Compliance Officer. This is case number 216-5137. Accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 9018 North Travis Drive, Citrus Springs. The property owner is Edward Thomas and Don Thomas. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on May 20th, photos taken on June 3rd at my corrective action inspection, and photos taken on my final inspection on July 19th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt, signed for on June 10th.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect there is no response. Without objection, what's been proposed as Exhibits A and B are evidence.
On May 20th, I conducted my initial inspection for accumulation of junk and debris and observed a mattress, discarded furniture, and other debris, which is a clear violation of the ordinance listed above. As of my final inspection on July 19th, there has been some progress made. However, there still remains debris near the mailbox. There's still that piece of furniture, and the trash is not contained, and there's some small items on the side of the house.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with administrative costs, to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the owner's real or personal property. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county law, which may also be incorporated to the lien.
Thank you.
Next two cases on the agenda, Nancy Burgess and Richard and Nathan Register, case number 2161948, Code Officer Alan Jonathan, page 9 of your agenda, and 10. Thank you.
Good afternoon again.
Yes.
Alan Jonathan, Citrus County Code Compliance Officer. This is case number 2162086, unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances, and case number 2161948, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 4615 North Tumbleweed Trail, Hernando, Florida. Property owner is Burgess Nancy and Register Richard and Register Nathan. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 6 April 2022, compliance inspection on 3 June 2022, and photos of my final inspection conducted on 19 July 2022. Exhibit B, a copy of the notice of violations, copy of notice of hearings, posting affidavit, and a copy of the posted notice of hearing on the notices of hearing on the property.
Is it within my authority as special master to get coffee, or is that?
You can get
I'm
coffee.
joking.
You can get coffee.
If my words start slurring,
I thought you gave it up.
at any rate, I did for about 2 months. Without objection, what's been proposed as Exhibits A and B are evidence. Is there anyone from the public who wishes to be heard on this case? The record reflect that there are none. Okay, so Exhibits A and B in each case.
Alan,
Yes, sir. Yes,
what
ma'am.
was your first inspection? The day of
It
your
was 6 April.
6 April 2022. On 6 April 2022, I conducted an initial inspection and observed the property to be in violation. On 6 April 2022, notices of violation were issued for unlicensed vehicle and junkyard conditions, which is a violation of the ordinances listed above. On 3 June 2022, I conducted a compliance inspection and observed the property to still be in violation. On 7 July 2022, I posted the notices of hearing on the property, and as of my final inspection on 19 July, the property remains in violation, although they've made tremendous progress. And I spoke to whoever the gentleman was that was there yesterday. He had been working very hard to clean. I guess they had some squatters sitting in there or something. So I wanted to give him some kudos for that.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the Special Master assign a fine of $50 per day per violation, along with the administrative cost, to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violations and the respondent's actions relative to the violations. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation in each case. Property owner will be granted 60 days from today to abate the violation in each case. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed in each case. This fine will be recorded and will constitute a lien on the real or personal property of the owners. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law, which may be incorporated to the lien.
Thank you.
Yes.
Next case on the agenda, James P. Gibson, case number 2163450, Code Officer Alan Jonason, page 17 of your agenda.
Did we do the Cox case? Oh, I'm sorry. Okay, gotcha.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2163450. Unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 4925 East Stokes Ferry Road, Hernando, Florida. Property owner is Gibson James P. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photo taken during the initial inspection on 29 April 2022, photos of a compliance inspection on 3 June 2022, and photos of my final inspection conducted on 19 July 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, posting affidavit, and a copy of the posted notice of hearing on the property.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there's no response. What's been proposed as exhibits A and B are evidence.
On 29 April 2022, I conducted an initial inspection and observed the property to be in violation. On 29 April 2022, a notice of violation was issued for unlicensed vehicle, which is a violation of the ordinance listed above. On 3 June 2022, I conducted a compliance inspection and observed the property to still be in violation. On 7 July 2022, I posted the notice of hearing on the property, and as of my final inspection on 19 July 2022, the property remains in violation.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask that the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
You said $50?
$50,
okay.
Yes, sir.
The property is found in violation. I adopt the county's proposed findings of fact. The owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a $50 per day fine will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Mr. Gibson. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county law, which may be incorporated into the lien.
Thank you.
Thanks.
Next three cases on the agenda, Kathy A. Sirachi, case numbers 2164842, 2164841.
The third one is a different address.
Yes. Oh, is
okay.
Yeah.
Oh, okay, sorry. I thought that was a different one.
Nope, no worries.
Next two cases.
Okay.
Case number, Alan Jonason, code officer on the case, pages 27
Why can't we
and
present
28.
those? Why can't you present those together?
I guess there's a separate address for.
I mean, we can.
No, I just didn't know if there's a reason. Okay.
Yeah, two of the violations are on one address, the same property owner, the other one is on a different address, near there, but not.
Well, the point is notice to the owner, so personally, I don't know if there's a due process issue with it, but.
If you're okay,
I am okay with it.
I can do trips.
I can handle it, I'll tell you.
Let's do it.
Okay, awesome.
And case number 2164834, page 29 of your agenda.
Okay. Alan Jonason, Citrus County Code Compliance Officer. Case numbers 2164841, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. 216-4834, accumulation of junk and debris on a different address, 465 South Smith Avenue. Case number 216-4842, unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address for the accumulation of junk and debris, case 216-4841, 216-4842 is 500 South Arlene Avenue, Inverness, Florida. The address for 216-4834 is 465 South Smith Avenue. That's Inverness, Florida. Property owner is Srirachi Kathy A. or Kathy Ann. Good service via signed certified mail receipt and posting into the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Photos taken during an initial inspection on 18 May 2022, compliance inspection photos on 17 June 2022, and photos of my final inspection conducted on 19 July 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail receipt.
And so we've got exhibits A and B in each of the three cases?
For all three cases,
Okay.
yes, sir.
Is there anyone from the public who wishes to be heard on this? Let the record reflect there is no response. Is Ms. Srirachi here?
She's not.
Okay. I would have asked if she has any objection to hearing all of these three. I think, due process is the poll star in a quasi-judicial proceeding, but, I don't think that there's any aspect of due process that isn't obeyed by having these three at the same time.
This is for these two, A and B is for 500 South Arlene.
Okay.
Both cases?
Yes. Oh, yeah.
And then this is A and B of 465 South Smith.
Okay, thank you.
Yes, sir.
Exhibits A and B in each case are admitted as evidence.
On 18 May 2022, I conducted an initial inspection and observed both properties to be in violation. On 18 May 2022, a notice of violation was issued for junkyard conditions on both properties, which is a violation of the ordinance listed above, as well as a notice of violation issued for unlicensed vehicle on the property at 500 South Arlene. I conducted a compliance inspection and observed that the property remained in violation on 17 June 2022. I have had brief contact with the property owner, but nothing since. Said they would get it cleaned up, taken care of, but nothing since then. As of my final inspection on 19 July 2022, both properties remain in violation.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, per violation, per address, along with the administrative cost to begin after the date you deem sufficient to abate the violations. This amount was selected based on the actions of the property owners once they were advised of the violations. This amount is appropriate given the severity of the violations and the respondent's actions relative to the violations. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation in each of the three cases. I've reviewed the exhibits that confirm that. The property owner is granted 60 days from today to abate the violation in each of cases 216-4834, 216-4841, 216-4842. If the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Ms. Srirachi. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the owner shall be responsible to pay all costs required by county law, which may be incorporated into a lien.
And sir, that was $50 per violation on
In each of the three. Yep.
Thank you, sir.
Thanks.
Next case, Cornell B. Cox, case number 216-5788. Officer J.C. Charlton, page 14 of your agenda.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 2165788, unlicensed and inoperable vehicles, violation of Chapter 20, Article 4, Section 20-41, the Citrus County Code of Ordinances. The address is 12959 West Cornflower Drive, Crystal River, Florida. Property owner Cornell B. Cox. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos I took during my initial inspection on May 25th, corrective action inspection on June 16th, and my final inspection on July 19th, 2022. Exhibit B, copies of the notice of violation, the notice of hearing, photos of the posted property, and a copy of the posting affidavit I completed.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect there's no response. And without objection, what's been proposed as Exhibits A and B are evidence.
On May 25th of 2022, I conducted my initial inspection. I observed a white unlicensed truck on the back of the property. I've had contact with the property owner and explained the violation. He stated the truck is on the back of his property and away from the road. I explained the violation and told him the property would still be in violation if the vehicle is not, licensed or removed from the property. As of my final inspection on July 19th of 2022, the unlicensed truck remains on the property.
You explained the violation to him?
Yes.
He doesn't care? Well, I mean, what was his response when you explained it?
He stated it was on the back of the property.
So it's just an unlicensed truck?
Yes, yes, sir.
What is someone supposed to do with a truck that, I mean, if they just don't want to have it licensed? Do they have to just junk it?
It could be in an enclosed structure.
I see.
If it's a project, vehicle or, like.
Okay. So as long as it's in a garage or it's enclosed or something.
Yes, sir.
All right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests the special master assess a fine of $50 per day, along with the administrative costs to begin the date after you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions relative to this violation. We would also ask the special master additionally find that it is respondents' responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owner. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. Property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
Thank you.
So what's George's message?
Do we want that on the record?
I just turned it on.
Okay, well, the time is 1:19 and this hearing is adjourned.